A very good evening to everyone. I welcome you all to our channel for the drafting marathon for CS Professional New Syllabus. Now, I will be taking you all through this entire marathon, and I can guarantee you I will try to cover over 50% of your entire syllabus. And I'll tell you the planning strategy also for drafting. So before I start, let me tell you that I have with me the scanners. The scanners are the past exam questions along with the ICSI model answers. So it covers the latest attempt, that is December 2024 attempt questions, as well as answers have been given as institute would want you to write. So you can get it from our website Jahangir Tutorials. Okay. Second, I have made something which is a limited time offer, which is a dream badge. A dream badge gives you access to the paid lectures at a nominal price, like around 299 rupees. You will get access to all paid lectures for all the chapters, and plus you also get a very big discount coupon inside where you can use it when you're enrolling with us. Okay. Now the dream batch is obviously a limited time offer. It is valid and it will be there only till your June 2025 attempt. So the links are in the description of the video. Go ahead and join. Thousands of students have already joined and are taking benefit of the lectures. I've put out my schedule, okay, where I will be taking the marathons for all the executive as well as professional, okay. Now with this we begin with our marathon. Now the marathon that we are going to start is for drafting. Okay. Now let me give you some insights for your drafting subject. Okay. Now I will be telling you a very simple hacks how to approach your drafting paper and preparations. Okay. So the very first thing is, let me show you the breakup. Okay. So 70-30 breakup is there. Your drafting paper has two parts. This is 70 marks, okay, and you have the part B, which is your 30 marks. Okay, so this will be 30 marks. But the real bifurcation, okay, which is not told to you and which students normally miss, is what you need to note down. Okay, so I'm telling you the strategy for your paper, how it should be. That when you see your drafting exam paper, okay, it's divided into two parts. Drafting exam paper is divided into two parts. Your part 1 will be your theory, where actual theory will be asked from your entire ICSI module. Remember one thing, that not a single word will come outside your ICSI study material. We cover the entire ICSI study material and you can go and study from that as well. Okay, so the full theory is there. And the second part is where they ask you drafts, to make certain drafts. Now, do you know the bifurcation? Normally, students don't know the bifurcation only. Okay, it's not told, it's an untold thing, but we know through experience and through looking at the past exam papers. So, around 60 to 65 marks comes as theory, pure theory. And your 30 to 35 marks in your examinations, okay, your 35 to 40 marks. Okay, so we can say your 35 to 40 marks will be your drafts, where you have to do the actual drafting. Okay, is this clear? It's very important for you to know. Normally this 30-35 marks is a easiest thing to get. So it is easy to score here, and from this 30-35 marks you can easily pull off around 20-25 marks easily, okay, with little preparation. And then you have to study your entire theory from the module. I'm going to cover the drafts, all these drafts for you in one go. So all the drafts which is around 40% of your exam paper, I will be covering now. Good to hear that? Yes or no? Everyone in the chat box, good to hear that. I will first be covering how to draft, and I will knock off 30 to 35 to 40 marks of your paper in the very beginning, and that too in a fast paced manner. So I will cover this in your 30 minutes. Okay, 30 to 40 minutes. Your entire drafts I will cover in a very beautiful sequence. I have made something where I can, that's how you can cover. I can cover everything from the module. Good to go. Everyone in the chat box, excited or not excited? Everyone ready for the drafts? I want you all to just be a little participative. Okay, so it will help me do it. Okay, great. Ashwarya, great. What about others? Now remember this thing. Okay, the drafts we will be doing. Now I will be referring certain drafts, and these drafts you will get from my website. Okay, you will get it from my ICSI, my www.jahangirtutorials.com. You go to my website jahangirtutorials.com. Okay, then go to CS Professional. In CS Professional you will see this draft common format. Okay, you go ahead and download it, and the drafts will open up, okay, so these are the drafts that you need to know for your examination, and 40 marks will be covered from your examination from these drafts only. Okay, from these drafts only it will be covered. Everyone ready? So I will be starting with the drafts. Okay, I will also see that you get it in your Telegram group and the your CS Professional WhatsApp group. The links are in the description. I will share it there. Okay, so very important, the drafts. Let's start. Okay, now before I start teaching your drafting, let me know in the chat box. Excited? Ashwarya is excited. Jan's okay. 40 marks I'm going to cover. I'm not joking. You open anything from your module, you will see that it's covered. Okay, 40 marks I'm going to teach you of drafting, covering in one flow. In 30 minutes you have to be with me, and I'm going to cover this entire draft formats for you. You have to, where will you get this draft format? On our website you download, you will get, and also in my WhatsApp groups I will share it after the lecture. Okay, so we better to get it from the website only. Let's start. Okay, let's begin. Everyone, I want all of you all to be responsive. Take a book and pen, be ready. 40 marks I'm going to cover in the very beginning in half an hour. Okay, everyone in the chat box, GTG or excited. I want you all to write GTG and excited, and second, like the video if you not yet like the video. Okay, so I'm going to cover the drafts. After that, I guarantee you don't need to do drafting after that. You don't have to look at the drafts. Everything will be on the tip of your tongue. I'm going to show you strategies, etc. Sir, how I can be rest assured that learning from you is going to be good? So pay attention that okay, so in my practice also I will show you all these drafts that we do. This is all practical drafts. See this, these are practical drafts from cases. Okay, so I know all those things. It's not just we are into practice as well. Okay, so it's not that if you go to see a bail application, how a bail application is written, anticipatory bail application from real life point of view. Okay, so I have obviously from all the real cases I have made these drafts. So you can see this is a real court draft that it has been used in court. Okay, all of this has been used in court. So if you go to see any of this particular draft for, let's say, going to sessions court. Okay, so when I go into sessions court, how it will be there, how the drafting is done, everything I'm going to show you in one go. So from basis of all the practical stuff, I have made my drafts where I will be teaching you. Okay, so let's begin. Okay, just looking, everyone has liked the video, no? Okay, excited, Prashant, Roshit, okay, Kirtana, great. Let's begin. Hi. So we begin with drafting part in your syllabus. Now understand that drafting will come for around 40 marks. 40 marks in your examination, and it's super simple provided you know the strategy. Now let me tell you, the drafts will come from the following only. The drafts will be based from the following. The first one will come drafting of agreements. Okay, so how to draft agreement, whether it be a partnership agreement, whether it be a sale agreement, whether it be a mortgage agreement, where two parties are agreeing on terms and conditions. Okay, so whether it be a mediation agreement, etc. So all of this will be the same. Arbitration agreement format will remain the same, where two parties have decided something and they want to put it down. The other types of format is called as your court formats, when you appear before courts. So as we are company secretaries, we are advocates, we appear before courts. So now in court there is no agreement, there is a fight, there is a dispute. So it will be in the format of the court. So you'll write the name of the court, and it will come the accused, or it will come as a plaintiff versus the defendant. So the format is different for court formats. The third format will be for notices or letters. Okay, will be for letter. So letter writing we've already done in your school. Answer is it will be the same. It will be to, then you'll write the address to whom you're addressing it, then you will write your subject, then you will write dear sir, then you will write the entire contents, and in the end you will give your yours faithfully. So these are letters. In letters we have, like example, from legal point of view, a letter is a show cause notice. A show cause notice is a letter where we will be addressed to you, and you will so they'll say draft a show cause notice or draft a legal notice. Very simple, legal notice. Okay, so that's a letter format it will be. Okay, and the fourth one is miscellaneous. Okay, miscellaneous, which I will tell you which other stuff come, but all the three your exam questions will come from these formats only. So now we will be seeing agreements, how to draft agreement. Any agreement, after I show you the format, you will be able to draft. Okay, then I will show you court formats. Any court format you pick up from your module, you will be able to do. Not only appearing before the court, which is filing an application or petition, even appeal format I will teach you. Appeal format is slightly different, even that I will teach you. Letters are there, which we will see: legal notices, show cause notices, sometimes writing a letter to the government, etc. Okay, that will come. And then miscellaneous are those public advertisement, which when we do the chapters that we will do. So these three are guaranteed coming in your exam. 110% a draft will come. 100% will come from the top three. Okay, these three it has to come, and 40 marks. Chalo. Now we will start with agreements. How is an agreement formed? For example, okay. So we are doing first agreements. So agreement format is here. Okay. I will be sharing this draft in my WhatsApp group, so you can join there, and one of the drafts you can also get it from my website. Now let's see. This is the format for a agreement. Sir, any format? Answer is yes. Any kind of agreement asked, the format will remain the same. Mark it is important. Okay. Now, first thing is you will write the title of the agreement. Whenever they tell you draft a agreement for sale deed or draft an agreement for a mortgage deed, you will write the title. Okay. So title will come here. Sale deed, sale agreement, partnership agreement, deed. It's the same. Okay. The parties are agreeing and it is coming down. You'll write that, and then you start off with, always agreement has to be mandatorily started by this agreement or this deed of title, whatever it is, okay, is made on so and so date, is made on so and so date at Mumbai, the place you will write. Here you will write the date, and then you write the format. The format will be between. Now you are writing between. Okay, between party 1. I'll tell you how to write it. and party 2. So obviously what are we doing? We are entering into an agreement. Okay, we are entering into an agreement. So this dash agreement made on so and so date at so and so place between party 1 and party 2. This much is clear. Now how to frame it, pay attention. Now you will write that Mr. A, now for example this is a person. This is a person. So you will write Mr. A, Indian inhabitant, resident at so and so place, hereinafter called as the first party. So here you will call him as the first party. You can also, if there is a specific word to him you want, you can write that also. Hereinafter called as seller, hereinafter called as a mortgager, hereinafter called as a lessor, hereinafter called as a licensor, hereinafter called as the patenter, inventor. So all those you will write. The expression, this first party, this expression shall, unless repugnant to the context, shall be deemed to mean and include his legal heirs, administrators and assigns of the first part. So this is a legal language. For all this you have to write, for all you will write that the word first party, unless repugnant, unless a different meaning is coming out, this first party shall mean that that party can also come, his legal heirs can also come, his executors can also come, administrators can also come, and assigns can also come of the first part. Now it is not mandatory, you can keep it simple also, but if you write like this, it looks and it looks very nice legal language, and plus practically also this is how it is written. I will show you some real agreements also, and you have to learn it, and definitely you have to write it for any of the agreements. And similarly, and then when you see, you write between called as the one part. That's the language of it saying. Okay, so again, this dash agreement made on so and so date at so and so place between party 1 hereinafter called as whoever, the expression shall include shall, unless repugnant to the context, shall include his legal heirs, his executors, his administrators, his assigns of the first part. And then you write the second, whoever is the party or the company's details. If it's a company, you'll write the registered address. Okay, and then you'll say the hereinafter called as the second party or the licensee, whoever it is, or the buyer. The expression shall, and same line you'll write, unless repugnant to the context, shall deem to include his legal heirs, his permitted assigns, his administrators, executive of the second part or of the other part. Okay, now till here we are done. Till here is the first part is done. Till here we are done with the first part. So any agreement comes, okay, no matter how surrogacy agreement, I tell you, it's anything, but you will write the same format. This agreement, let's say a sale deed, etc., mortgage deed, a bank guarantee deed, made on so and so date at so and so place between party 1, the expression shall include, unless repugnant to the context, party 1 of the first part and of the second part. Okay, that's what you write at the start. Now the second part is called, technical term of this second part, which starts with the term whereas. See, it will always come as whereas and whereas. Okay, this will be called, this part will be called as a recital. It's a language. Remember this, I want you to write it down. Recital. Okay, what do you mean by the term recital? Recital is an introduction to the agreement. It is a recital. A recital is a intro to agreement. So today, if I want to understand any agreement, what they have to say, the highlights of the agreement will be in the recital. Always the recital should include offer and acceptance. What will it include? Offer and acceptance. Recitals could be of two types. Okay, recitals will be of two types. This is just for theory point of view. One is called as narrative recitals, and the other one is called as introductory recitals. Okay, so your part 1 is called as narrative recitals, your part 2 is called as introductory recitals. Sir, what does it mean? Please explain. And always third line you have to write that it starts with whereas. It starts with whereas is capital. Whereas. Okay, so let's see. here if I'm selling my house and you are buying the house, so the recital will be something like this. Whereas, so first you have to write offer and acceptance, you have to describe the agreement. Okay, so whereas, and don't directly jump into it, first describe the first party. That is called as narrative recitals. What is narrative recital? Where you introduce the parties, where you give a, in recital you introduce parties, and here in introductory you introduce the agreement, the what kind of agreement it is. So whereas party 1 is the owner of the house mentioned in the schedule, and whereas party 2 is desirous of purchasing the house. So I gave two narrative recital, introduction of the parties, whereas and whereas. So I'll write, and then I write offer and acceptance. This is very, very important to write. Okay, offer and acceptance. So how will you write? Whereas party 1 approach party 2 to purchase the said house, and whereas, now acceptance, and whereas the parties have agreed, that shows mutual agreement on the terms and conditions mentioned below. Clear, everyone? So how will we start a recital? Whereas party 1 is in the business of so and so, and whereas party 2 is in the business of so and so. So my narrative recital is sorted. Describe the parties, what they do. Then I will write and whereas, now offer and acceptance. Okay, and whereas, so here in this you introduce the parties. In this you can mention the offer and in this introduction to the agreement you will give a offer and acceptance. So you will tell what exactly happened. Party 1 approached for buying the house, and party 2 agreed on the terms and conditions mentioned below. So this is there, that whereas for every single agreement or deed, this is the format. No matter what, open any part of your module, this is the format it is there. If it is not, module is incorrect. Guaranteed. Okay, we do it practically day in, day out. So you can follow this, and these are from practical drafts. So whereas the first party, whereas the second party is in the business of so and so, second party is in the business of so and so, and whereas the first party is approach, shows what? What does it show? Shows offer. And whereas the parties have mutually agreed, what does it show? Shows a agreement. Concept clear? And then once you're done with that, then you will write something called as this. Now this agreement witnesses as follows. Now this agreement, this deed, even technical word you can also say indenture witnesses as follows. Means the same thing. Okay, indenture is where there are two or more parties, is called as an indenture. So they say now this agreement witnesses as follows. So what did we do? We first introduced the agreement title. This agreement made on so and so date at so and so place between so and so person, first party, second party. Now I start with my recital. Whereas the party 1 does this business, party 2 did this business, offer and has approached for so and so, and this has agreed on the terms and conditions mentioned below. Clear till here? Now we start with the next part. The next part is technically called as testatum. Sir, what do you mean by testatum? So testatum is a detailed terms and conditions. Okay, so whether detailed terms and conditions of the agreement are given will be the testatum, and it always starts with now this agreement witnesses as follows. Okay, instead of agreement you can also write indenture. Indenture is basically a agreement where there are two or more parties. So just technically you can write, it's the same thing. And now you start with the terms and conditions. Okay, now terms and conditions you have to write. This I would advise you all to think now what is the agreement about. If it always, no agreement is valid without a consideration clause. So start with the consideration clause. In consideration of, now I am writing the detailed terms and conditions which you can write in your own language. Consideration, in consideration of so and so which has been paid on so and so date at so and so date, where the consideration has been paid, the receipt of which is hereby acknowledged and attached. Maybe see, this guy paid the money. If I bought the house, I paid the money. So the payment details I have attached to this agreement. For receipt of the consideration, the party has done so and so. So own words you can write consideration clause. Now, in every agreement, there will be a covenant and indemnity. In almost all the agreements, there will be a covenant and indemnity. Sir, what is a covenant? Covenant means a promise. Covenant means a promise. And if the promise is not followed, if the promise is broken, then you will have to indemnify. Okay, you have to pay for losses. So it will be that party A hereby covenants as follows. So one of the party is giving a covenant or assurance as follows, that they have the right to sell, that their property is free from all encumbrances, that the party has complied with all the laws, etc. Now with covenant, the other thing will come as a indemnity. So now this you can see, which I'll give you, I've given multiple clauses, you can see which you can fit. In indemnity, I will write that if any of the above covenants, representations and warranties turned out to be false, incorrect, misleading, then party A and any party which suffers a financial loss, okay, will be the other party will be responsible to indemnify the other side. So if any of the covenant, representation, warranty is found to be false, inaccurate or misleading, okay, then the party A, then one of the parties is hereby agreeing to fully indemnify and hold harmless the other side against such losses. So it's a sentence that you frame and you move forward. Then one force majeure clause also you can write in any agreement, that no party shall be held liable for an act which is beyond their control. So neither party shall be held responsible for the failure or delay, okay, if any of the unforeseen circumstances have occurred and including but not limited to fire, war, government restrictions, cyber attacks, etc. Nowadays what happened after COVID, force majeure clauses become very, very important. They are saying that, listen, if today there is a war has broken out, or if there is a COVID, now if you see the news again, new COVID has come up. So if any of this is there, okay, or any of this thing is there, then the parties will not be held responsible. Then you can write one other clause, which is confidentiality clause. What is confidentiality clause? That both the parties agree to maintain all the information exchanged under this agreement confidential and strictly protected and shall not be disclosed except with the written consent of the other party. Write this line, this is done. Then any agreement is there, obviously what we've written, consideration clause, promises and indemnities. Then we've written about a force majeure. Then we can also write that if it's an agreement and we want to end, for example, employment agreement, you want to end the employment agreement, service agreement, then you will enter into a termination clause. Okay, so either of the parties can terminate the said agreement by giving a 1 month notice to the other side. Finish. Then you can write mandatory, nowadays in commercial agreements they are writing is a arbitration clause. That if, and how will you write the sentence, that if any of the parties fail to resolve the dispute amicably, that if the parties are unable to resolve the matters, solve the matters by themselves, mutual way, then they will refer it to arbitration, and Arbitration Conciliation Act 1996 will be applicable. So this simple lines you can write and move ahead. Now in agreements you can have restrictive covenants also. Restrictive covenants means what? That if I am giving you my intellectual property, I will tell you don't do research and development, don't start a competing business with me, or with my employee also I can have restrictive covenant that you will not join my competitor or within this area, or you will not start a competing business, or you will not start doing R&D on what projects we have given you under the company for working, etc. So how will you write it? For a period of XYZ years from the execution of this agreement, the party agrees not to solicit my clients, not to directly or indirectly approach or attempt to solicit my clients, do any business, etc., or engage in a competing business in so much locality. That's it. Non-compete also. You shall not compete with the business from the expiration of so and so time within an area of so and so. So you can mention that also. Okay. And now all these clauses then you will write, and after you maintain. So now remember these clauses that I've told you, you can note it down. make it and or maybe learn it from my draft, you'll be sorted. After that, then you will write in witness whereof. Now we are done with which part? Testatim, detailed terms and conditions. Now we are going to start with testimonium. What you are starting with? Testimonium. What is a testimonium? It's a closure. How do you close an agreement? Closure of a agreement. So closure, or is the last part of an agreement. It starts with the word in witness whereof. What does it start with the word? In witness whereof. In witness whereof. The parties have set their hands. Okay, have set their hands means they have signed on the dates mentioned above. You can write this line and close it. That in witness whereof the parties have hereby set their respective hands. Set their respective hand means what? They have signed. Now don't write the word sign. It doesn't look legal. Legal language is what I'm teaching you. The parties have set their hands on the day mentioned herein. And then a deed by default has to be signed, sealed, delivered. So you will write the line signed, sealed, delivered. Then name of party 1, signature of party 1, with name of party 1, signature of party 2. So basically in the end you can write this line that party 1 will sign, party 2 will sign, witness 1 will sign, witness 2 will sign. Okay, so this is the signature part and you will end the agreement. Concept clear? Yes or no? So this is nothing but a agreement which I have taught you. All the agreements, you open any agreement in your module, you will get this format only. Okay. Now, the second thing which I wanted to tell you is, is some other kind, like a miscellaneous things, which a little bit of variation is there, like a will. Now, suppose if you are making a will, we are making a will. So it always will is made in first person, because obviously I am making my will. So I am writing that I, aged so and so, residing herein. So now this format will be different. This comes in miscellaneous formats. Miscellaneous formats. I told you. One is agreement format. I taught you. This is one of a miscellaneous, means other kind of agreements which is there. So will, I, and very simple. It's your own language. Will, there is no law, no format prescribed by law. So I do hereby declare that I have not made any will, or I hereby revoke all my earlier wills. So this is the line that you write. I do hereby declare that I have not made any will, or I hereby declare that I have revoked all my earlier wills. I do hereby declare that this is my last will and testament. And then you write that I declare that I am, now you write about your properties, that I declare that I am in possession of movable property, I am in possession of immovable property. The details are mentioned in the schedule. Okay, now I am a senior citizen and I am physically and mentally fit and have absolute power to write this will. I hereby declare that I have the following legal heirs. I hereby declare that I hereby bequeath means give my property to so and so person. I hereby declare that after my death, the property shall go on to and devolve among the following, in the following proportion. So you give the name, share, how much percentage share is there you want to give, and I am registering this will voluntary and without any force or compulsion, and I hereby declare XYZ to be my executor, who will, once you will die, who will go and ensure that the property is transferred, etc. Okay, and again the last part is in witness whereof I have hereby set my hands on the date mentioned above. Okay, and then you write your sign and signature. Clear till here? So this is done. Format is done. One of a miscellaneous format I showed you, which is a will. Okay, now all this leave and license, everything will be in same format. Let's see if there is something new to teach you. Now, another miscellaneous format which I'm going to teach you. Miscellaneous format, okay, which is like a little bit different from an agreement. Okay, is a power of attorney. It's a little bit different, but this also they have asked in the exam. So only 4 kinds of drafts comes. One is agreement, which I've taught you. The other one is court formats, which I will show you. Third is your notices, which also I will show you, and the fourth one is Miscellaneous means some little bit different kinds of thing which we are doing. Now whenever you see power of attorney, it will always start know all men. Okay, now or know all men, that you can write it in first person, that it's a language. So in power of attorney you will write this language in the start. Know all men, just a language, legal language, that's it, there's no logic. Know all men, that and then you start, I am son of so and so. Now what is a power of attorney? I'm giving a power to someone else, a power which I have, so I become the donor of the power. So I will be called as a donor or the principal, and the other guy will be called as the donee or my attorney. Okay, I do hereby make a particular bill, make a particular POA, giving them the following powers. So I bequeath onto the person the following powers. I hereby appoint XYZ to execute and perform the following things, namely to sell the property, to execute this, to appear before the authorities, what all powers you're giving. And one important line you will write, which is mandatory, that I understand that that all his acts will be deemed to be my acts. Okay, and I hereby ratify and approve all the acts that he will do lawfully under this agreement. And the principal hereby undertakes to ratify and confirm whatever the attorney purports to do in good faith. So whatever my attorney is doing in good faith, I undertake to ratify it and confirm it, and then I will sign. In witness whereof I will sign. Okay, so how will he start a particular power of attorney? So in power of attorney, when I'm saying know all men, that I have hereby given a power to XYZ, hereinafter called as my attorney, to do the following acts. All the acts will be mentioned, and one line I will write that I hereby agree and agree to ratify all the acts of my attorney, that which he will lawfully do under this agreement, under this power of attorney. And also you will write, I also understand that all the acts done by him are deemed to be my acts. Okay, so this is another miscellaneous agreement that is there. Okay, a promissory note, very simple, nothing. So promissory note, I promise to pay so and so a sum of rupees so and so, okay, as a friendly loan, and you sign it up. That's it. I receive, this is the format, witness to witnesses, you keep it. Not very important. So a power of attorney. So you see again how it is written. Now power of attorney could be a general power of attorney where I give for multiple purposes, or I can give a special power of attorney for a very specific purpose. So for example, if the company has given a power of attorney to its company secretary to set up a bank account or to incorporate a new company, so then it will be written that to all men, to whom this power of attorney, no, so you'll write to all men, know all men, that's how you can start, remember that. Okay, I do hereby give the following powers to my attorney. Okay, I do hereby nominate, appoint him as my true and lawful attorney to do all the following deeds. So this is how you start. I hereby nominate, constitute and appoint XYZ as my lawful attorney to do the following acts. You mention which all acts are there, and in the end I told you this is mandatory. What is mandatory? That to ratify and confirm whatever they have is deemed to be my acts. Okay, and then you will sign, seal, delivered, so that you can write. So this basic format also is of a power of attorney, you can write. Okay, moving forward, then the third is about a gift deed, a little bit variation only. Now this is also another miscellaneous format. It is of a gift deed. Okay, it is a miscellaneous format, something minor difference will be there, that's why I keep it a miscellaneous, etc. miscellaneous format. Now again, this gift deed made on so and so date, okay, between so and so person, the person who's giving the gift is called as a donor, and the person who's getting the gift is called as a donee. One important line, it's just like an agreement, But one important line in case of gift, you will write that the gift has to be accepted. So you will say that I am the donor of the gift, I am donating my gift to so and so person. Maybe if I'm giving it to my child or etc., in consideration of love and affection, I give it to them. Most important which I am looking for is the consent, that hereby they have agreed to take up the said agreement. The word, because a gift has to be accepted. Okay, the shall mean of the other part. So there will be one line mandatorily that has to be written, that they hereby accept the gifts. Okay. Now, love and affection do hereby assign to them. This is the own language you can write format I am teaching you. Now there is one line which is called as to have and to hold. Okay, to have and to hold. Now this word to have and to hold comes in property mostly wherever rights are given. So to have and to hold. This means habendum. Okay, I want habendum. Sir, what is habendum? Habendum is the amount of rights that you are transferring. It is the amount of right transferred. Okay, so whether this right is a absolute right or it is a restrictive right. Understood? So absolute right means you are giving free from all encumbrances. So this will come in case of sale properties. So when I sell the property, I will obviously say that this particular property, to have and to hold this property free from all encumbrances in perpetuity. It is like a sale. Restrictive covenant. What does a restrictive habendum mean? Restrictive is the right transfer. The amount of right transfer is not absolute. It's not complete. It's not 100%. It's not forever. So it could be in case of a lease agreement. It will be so you will write to have and to hold the said property subject to the restrictions and terms and conditions mentioned in this agreement. So 5 years, etc., which is there. Clear till here? That's it. Okay. And then one last line. There is just the word you have to remember. In case of lease, whenever you mention the rent, lease rent, how much it is there, description of property, you will have to write now that I'm giving this property on rent for so much time, etc. So this part, a clause where you contain all of this, is called a redundum. Okay, what is redundum? Redundum is basically details of the lease specific things, lease rent, for how much tenure it is there, the tenure, all of that specific is called as redundum. Just theory you have to remember, it's important, that's why I'm telling you. So with this, I have completed your formats for your agreements and miscellaneous parts. Okay, now I'm going to show you agreements, the format for your plaint. Okay, I'm going to show you format for court formats. What formats I'm going to show you? Court formats. In court format, a miscellaneous application could be a bail application. Clear till here? So let's see. Now we are going to see in court. Now obviously when we saw an agreement it had that, now it started off this agreement made on so and so date at so and so place between so and so parties, and now this then you write the whereas this one approach, that guy accepted, now this deed witnesses as follows. So there was an acceptance, there was an agreement. Whereas in court the format is completely different. In format of court, it's completely different. So now we are doing the second type of main formats that come, which is your court formats. Clear? Okay. Now let's see. So the format is also very simple here. If it is a plaint, okay, now pay attention. If it is a plaint, sir, what do you mean by plaint? So the person who files the application will file a plaint. So when you file the application, you have to write first the description of the court. The details of the court has to be written. So in the High Court of Judicature at Mumbai, this is just a language. In the High Court of judicature. Judicature is the basically the authority that gives justice at Mumbai, the place. So you give a description of the court. Then you have to write the application number. Then you will write the suit number, the court number. The suit number will be written. Okay, so then you describe the case details, and then you have to tell whether it's an original application or it is a appellate application. Okay, so then you have to write whether it's a original application or appellate application. Okay, so these three will always be the same. And the last part is under which section are you coming? Under which section are you coming? So for example, under the section dash of dash act. So for example, it's operation mismanagement. Okay, operation mismanagement. So you'll write under 241 to 246 of the Companies Act 2013. If you're going to NCLT, it's an original application. If you're going to NCLAT, it is a appellate application. And then normally when you go to the court, they give you the suit number. The application number will also be given. So this, before even starting what the case is about, you have to write the court details, the case number, the jurisdiction type, and the act under which it is there. Then you will write the details of party 1 in this format only. So I've shown you like this format is the most accepted format in the practical world. You write it in your exam also, you'll get extremely good marks. Okay, so then you'll write the details of the company. Okay, company having its registered office so and so. The plaintiff details will come. Then you write the word versus. What do you write the word? Versus. And then you write having its office of the defendant details. So what did we do? We wrote the details of the court, and then we wrote about the party details. But you don't write and, you write versus. So this one versus the other person. Okay. Then you start off saying, so till here it is clear. What do you write? You start off saying, plaintiff versus the defendant. Now you start this. May it please the Honorable Chief Justice of the High Court and his Lordship companions. So this is how you start. So how do I start? That may it please the Honorable Chief Justice and his Lordship companions, the petitioner most respectfully showeth. The petitioner above most respectfully showeth. Then you will start giving the facts of case. Facts of case. That whatever wrong has happened in the module, it will be given, that you will see. Clear? Okay. Just a sec. Okay. Okay. So you'll write the facts of the case. Normally in your plain language, you will write what happened in the case. And now you will write a few more points. Okay. I'm giving you pointers which you can write. That obviously you'll write the facts. Then you will write that it is within the limitation period. You will also write that you paid the court fees. Court fees has been paid. Okay. As per the valuation of the suit that has been paid. And the plaintiff will rely on certain list of documents mentioned in the petition, in this particular petition. So how do we start off a court case? So first we give in the description of the court the application number, the jurisdiction type, and the section number. Then A versus B. Then you start off your facts saying that may it please the Honorable Chief Justice and his Lordship companion, the petitioner most respectfully showeth. So the petitioner most respectfully showeth, put your facts of the case. Then in the facts, just towards the end, you write that the court fees has been paid, it's within the limitation period, and I will be relying on certain documents attached into this agreement. Now after giving that, obviously you given the facts of the case. Now why did you come here? For relief, right? So you will have the prayer or the relief clause. That in light of the facts stated above, the petitioner humbly prays before the honorable court the following. Now I am saying what prayer the petitioner or the plaintiff, what is he praying? That the defendant be asked to give me compensation, or injunction be given, interest be given during the pendency of the suit, the cost of the legal petition give me. So anything, you can, sky is the limit, you can ask anything, any relief. Okay, that ask the court that the defendant be ordered to pay so and so amount, etc. I can ask for injunction, I can ask for a valuer to be appointed, anything I can ask. Okay, the cost of the suit should be paid, give me interim relief, etc. And one line you should write in the end, any other relief if the court teams with, that also they can give me. And then you end it by writing this line after the prayer, that for this act of kindness the petitioner is in duty bound and shall ever pray. This is the language. For this act of kindness the petitioner is duty bound and shall ever pray. It's a language. You need to write it. Okay, this is there. I'll show you in real life cases. Exactly this line is written. Then after that you can write a verification. A verification is like an affidavit. So after you given the petition, then you will write the verification that I, son of so and so, hereby state that, hereby solemnly resolve or solemnly affirm that all the information given above is true to the best of my knowledge. One, and I have not concealed any facts. And then you give the date that you have done, and then you will write, lawyer will write identified by me, the lawyer's detail, through the counsel details will come. Clear? Plaintiff will sign, and then you, through means what? Through which lawyer you've done. So counsel details will come and done. So let's go through it again. What it is, the court details will be given, the case details will be given, the jurisdiction type and the section details will be given. Then A versus B, the petitioner most respectfully showeth, you'll give your facts. Then you'll give the relief that in light of the aforesaid circumstances, the petitioner most respectfully prays as below. Okay, the humbly prays that this honorable court may be pleased to order this defendant and give me all this interim reliefs, etc. Then for this act of kindness I will ever pray. Then I will give a affidavit, all the information given to the best of my knowledge. The party will sign and it will be through which counsel. So these are the details that you have to do. This is the format for a court format. Okay. Now remember, in the court format, when you are filing an original case, original application means first time you are filing. But if you did not win in the lower court, then you go in appeal. So I'll teach you appeal format also. Mark it as important. So appeal format also remains the same. Only in appeal format one additional thing will be added. Everything remains the same. Only one thing will be added, which is called as grounds of appeal. Why are you coming in appeal? That has to be told in a separate heading. Okay, let's see. Format exactly will be the same. Okay, what is the format? For format for an appeal, that in the court of so and so at so same place, same thing is there as above. You will give everything same. The petitioner most respectfully showeth. Now in the facts, now I'm showing you what additional is there. Okay, in appeal everything is the same. What extra you need to write? First you need to write that aggrieved by the aforesaid order, aggrieved, sad by what the lower court has passed an order. Because when I'm coming in appeal, some court must have given a wrong judgment, na? So I will be saying aggrieved by the aforesaid judgment, because in the facts I will say that there was a court that passed a wrong judgment against me. So aggrieved by the aforesaid judgment or decree, the appeal is hereby filed on the following grounds. And then you give the grounds for appeal. I told you that in appeal, this is new. In appeal, the grounds of appeal should be written. Why are you appealing? So I've given you all the points that you can possibly write. And in very technical words I've given you, so that when you write it looks very legal and formal. Okay. So what will you write in grounds of appeal? That basically the lower court has failed to appreciate the evidence. The subordinate court could not appreciate the evidence. They are erroneous. The judgment given by the lower court is erroneous both on facts and law. principles of natural justice are not being followed, opportunity being heard was not given, there's a complete miscarriage of justice. Okay, so all this, it's illegal, erroneous, and deserves to be set aside. So all the points you will write, and then you will write your prayer. Rest everything will remain the same in lights of the same facts. Pray what all relief do you want, and one of the relief will say that the appeal be admitted and the defendant, the lower court's judgment be set aside. Then everything, the verification will come, verification through will come, and that's it, done. Clear? Now this is all the real life cases which I'm showing you. Plaint before Bombay City Civil Court. This is all real life. How the format is there. Same format remains the same. The petitioner most respectfully states as follows. Then you write your prayer. Okay. The plaintiff prays as before. I have given the best format. You can follow it. Okay. Then one format I am going to show you for miscellaneous, which is bail application. It has come in the exam also. Bail application. Now bail is also before the court, but it is before a criminal court. And in criminal court, someone must be in jail, so he is asking for a bail. So in the court, bail application number you will write for which you are doing, and that's why you don't write plaintiff defendant. You write complainant versus the accused. So whoever is the complainant, maybe the state of Maharashtra, police station normally is the complainant versus the accused. So now we are seeing the format for a bail. Details of the court, bail application number, okay, criminal record number or that diary number will be given, and now you write, may it please your honor. This is miscellaneous application, so the format remains the same. On behalf of the accused above, it is most respectfully submitted, applied and prayed that the bail application be granted. Okay, the police have falsely implicated me. So this is the language you will write. The police has wrongfully put me into this case and arrested me without any reason. Okay, the applicant is neither required for investigation, all the grounds you will write that he has. What grounds you can write? That will not free from court of justice, will not tamper with evidence. Now this is the real life court draft I have taken. So that the applicant will not tamper with the evidence. The applicant will appear before the courts whenever it is needed, will present before the court whenever it is needed, and therefore he prays prayer that the be released on bail, okay, by giving a surety or a security bond. Okay, the cash can be collected by the police and any other relief which the court feels they can give me, and that is it. For your act of kindness, the accused shall be duty bound and shall ever pray. Okay. And this a little bit of extra miscellaneous parts are there, that also I have put down, wakalatnama, etc., but not very important. With this I have completed the formats for court, format for agreements. Okay, I have finished the format for miscellaneous applications, and now just notices. Notices will be like a letter writing only. So in letter writing, what do you write? To subject, dear sir, okay, and then you write the details and then yours faithfully, and done. You give your mobile number for signing, etc., whichever is there, which we will see when we are doing the part. This notices is very, very simple. Clear till here? So with this, I can guarantee you your entire past exam questions will come from here only. Okay, formats. And for these formats, around 35 to 40 marks of your paper will contain this. Clear? So that is it. I have done with my first part, which is making you understand how formats come and how you have to attempt these formats, which will knock off minimum 35 to 40 marks in your examinations. Thank you. Let me know in the chat box, have you all understood? Yes or no? You can keep the headings as me, not an issue. Okay, you can keep it. In website related to code, there is only there where to get this draft. So that, Prashant, I will share that draft also. For the agreements also, I will share it on the on my website or in my Telegram WhatsApp group after my lecture. Okay, so done. Till now, everything good. If you not like the video, like the video. Now we'll go chapter wise. Okay, Now I'll go chapter wise. Everyone in the chat box, have you all understood? Gautami, what about others? Have you all understood? Yes or no? Waiting. Everyone in the chat box. Yeah, so Bhanupriya, that should we keep the headings while drafting? Yes, definitely you can do that. Drafting, understand. See, you should also know that as a student, you should know what is right, what is wrong. So, in drafting is an art. There is no law saying that this is how you have to draft something. So the more visually better you can keep it, that is absolutely fine. So I draft that way, it's absolutely fine. You can keep the headings, and so many times leave and license agreement, mortgage agreements do have headings and clauses. Okay, so if you want, I'll just show you some real life agreements also, where you'll see it is there. Okay, so can you see this? This is a real life draft. So the heading is there, disablements, etc. So all the headings are there. These are real life code draft which are used, indemnity clause. So these are not this for this draft 50,000, 75,000 to 1 lakh is charged. Okay. So this is how dispute resolution, etc. is there. So definitely you can write all this headings as I have shown you. Okay. So that is it. With this brings me to starting the marathon. After the drafts, the other part, which is a 60 marks, I will start taking up chapters, sequence wise and completing it. Okay. So we'll just take a 5 minute breather, 5 minute breather, and then we will start with this chapter, lesson 1. Okay, from the module. Good to go, everyone. Till now, did you all understand in the chat box? Yes or no? I want every one of you all to write understood, yes or no. Then I know that you've understood, so I can move ahead. Clear? Come on, quickly. Understood, yes or no? Okay, great. So now I will be starting with lesson 1 after 5 minutes, and I will be completing it. Great. Ashwarya, Gautami, good. What about others? You all understood? 35 to 40 marks gets over just from what I have shown you. Ramya, great. Okay, chalo. Bhanupriya, great. Okay, so in 5 minutes I will come back and I will start with lesson 1 and complete it in one go. Till that, Prashant also great. Thank you. Do like the video, share it from for me. What you can do is share this video in your study groups. Tell your friends also. It takes a lot of effort to take all this and cover so much stuff. Just do that much. That's your gift to me. That's it. Okay. So I will come back in 5 minutes and complete your lesson number 1. Okay, guys, am I audible and visible in the chat box quickly? Okay, so am I audible and visible, everyone? Waiting for your responses. Am I audible and visible? Okay, great. So we will be starting and completing this particular chapter. Ashwarya, great. Chalo. Hi. So we begin with your lesson types of document. Now the types of documents that are covered is basically as a company secretary we obviously deal with a lot of documentation. So here they have spoken about documents such as agreements, deeds, newspaper advertisements, notices, okay, your company bylaws. These are all documents. So here we'll understand what are documents, etc. Now we will, I will be telling you all what is important from exam point of view and complete it. So the very definition of document is given under section 3 subsection 18. So a document basically is any substance on which information is being recorded. So any substance, okay, any substance, whether it be written, express, written, any substance, could be a wall, could be a paper, could be online, could be digital, everything, okay, where information is put up like figures, letters, marks, etc., okay, with the intention of storing or recording that matter. So what is, so at least we are doing types of documents. Let's know the definition of documents. So the most important document that you need to, the definition you need to know is given under section 3 subsection 18 of the GC Act. What is GC Act? It's a General Clauses Act where general definitions are given. In other acts also definition has been given for document like Companies Act, Income Tax Act, etc. But they give an inclusive definition. They say that document also includes all of this. Okay, so it includes letters, electronic, summons. So anything on which there is information with the objective of recording that matter is called as a document. Okay. Now we will be seeing what are deeds. So different kinds of documents we'll be studying in this chapter, okay, like your agreements, contracts, deeds, circulars, public notices, tenders. These are all some substance on which information is stored with the object of recording it. So these are all documents. Let's see, the very first and multiple times this will come, one of the most important is called as deeds. Sir, what do you mean by the term deed? Okay, so now if you go to see the deed, they go on and on, they give you examples of deed, sale deed, this deed, partnership deed, a lease deed. But what is the meaning? So there is no section under company's law that I can tell you that this is the definition. So there is no section, okay, which I can tell you. But what we will be referring to is the most suitable, comprehensive, beautiful definition given by my dear friend Norton. So he, from first only he was naughty. That is why they called him Norton. Okay. So remember that the definition of deed you will write. A deed is a instrument which needs to be signed, sealed, delivered. It needs to be signed, sealed, and delivered. Clear? So a deed, first of all, cannot be verbal, cannot be a deed. A deed has to be in writing. Okay, this is the best definition given, and this is what you need to quote in your exam. A deed is a writing on paper. Obviously, we see sale deeds, it's on paper, but also includes volume. Volume is basically any walls. Like in Egypt, they had written so many information on walls, or parchment. Parchments are basically, any kind of animal, what do you call, animal skin, etc. Parchment on their part is being written. So for example, if you have written on an animal something, that is also covered, some numbering has been given, that also becomes a document, a deed. So a deed is something in writing which may be on paper or any other substance. It will be signed, sealed, delivered. It will be signed, sealed. So parties will obviously sign it, will deliver to each other, and might require a seal of a court or an authority. Clear? Now, what did I tell you? I told that a deed is a instrument. Okay, now understand the word instrument. What does an instrument mean? Pay attention. An instrument means any document by which any right, title, interest is created, declared, assigned, limited, or extinguished. Okay, so just remember this line. An instrument is basically any document by which any right, title, interest is created, declared, assigned, limited, or extinguished. Sure, give me an example. Now, I'll give you a classic example. First of all, a document is anything which contains info. Okay, simple. A instrument is basically a document by which any right, title, interest is created, declared, assigned, limited, or extinguished. So maybe if I create a sale deed, I transfer that house to you. So it is obviously a document in which certain rights has been created for you. Example, I'll give you a proxy form. Example is in company law we do proxy form. So proxy form is also an instrument. Power of attorney is also an instrument. Why? Because you give some right, title, interest. You create it. Okay. Assign, declare, limit, extinguish. Okay. And the third thing is a deed. Sir, what do you mean by a deed? A deed is normally an instrument. So this all is there, which has to be signed, sealed, and delivered. So when we saw the definition of Norton, did you see the word instrument there? Yes or no? Sir, no, I have not seen instrument. But the meaning of the term instrument is written. See, where any R title, okay, for property passes means what? Title, interest. So where any RTI is created, okay, limit, extinguished, etc. has been passed. So you can write this line. A deed is an instrument on paper, volume, parchment, sealed and delivered, whereby any right, title, interest is created, declared, assigned, limited, or extinguished. This is the definition of deed given by Norton. You can write it. It's beautiful and easy to understand as well. Okay. Now, sir, what do you mean by the term agreement? So agreement, we know that it comes under Indian Contract Act. So when two parties agree, it becomes an agreement. So in Contract Act, now pay attention to this. So in Contract Act, what it is written? First, there is an offer and there is an acceptance. Moment you give an offer and acceptance, what does it become? Someone gives an offer, agreement, it becomes a promise, or we could say an agreement. Clear? So an offer given and you accept it. So there is a promise now that I give you an offer and you accept it. So now it's a promise. Lot of things will have to be given. I will have to give you the goods. You will have to pay me the money. It's a promise. All the promises set together are called as an agreement. So a collective of all. So promise could be one thing. Agreement is a set of all the promises that are there in the agreement. That I will give you, by what date you will give, what will be the quality, okay, all those things. So promise, so an offer plus acceptance will become a promise or an agreement. Okay, so what is an agreement? An agreement is a set of all the promises. Now further, pay attention that an agreement could either be enforceable by law, or it would be non-enforceable by law. Okay, if it is enforceable by law, so an agreement enforceable by law is called as a contract. What it is called as a contract. And a agreement not enforceable by law, anyone knows what is the definition? Called as a void agreement. Called as a void agreement. Now pay attention to all the terms, okay? Now all the definition. So all the section 2 contains the definition. So section 2A talks about an offer. Section 2B talks about the this talks about offer, this talks about acceptance. 2C talks about who's a promisor, who's an offerer, who's an offeree. Okay. Then we have contract. 2H. What I want you to remember here, most important. See, general, just to remember this, how much ever you can remember. 2A is offer, acceptance, details of who's a offerer, offeree, that is a promisor, promisee. 2D is obviously consideration, you can remember this. Most important which I want you to know is your definition of the term contract. Contract is an agreement enforceable by law. What is an agreement? An agreement is all the promises and set of promises collect together become a agreement. Simple. Okay. Now, types of agreement. Now, obviously, when you will read so many drafts, you will do everything is an agreement. Sale agreement, commercial agreement, agency agreement, collaboration agreement, all of those, and drafting will also come. Sir, then what is a contract? Obviously, an agreement which is enforceable by law, given under section 2H. What we have to remember? The section is section 2H. I want you all to write it down. At least this you have to write, okay? 2H. An agreement which is enforceable by law is a contract. So definition of the term contract is in 2H. This is what you need to quote, okay? And that's it. Then you can write, build it. We've done it. Now what is the difference between a contract? You give the meaning. Contract is basically an agreement enforceable by law. What is agreement? Promises and set of promises I told you. It may or may not be enforceable by law. And deed has to be signed, sealed, delivered. This line you will write. You will write the definition of not in. Okay. This is the main thing. Now, document. Now, other kinds of document we are talking about is a circular. So, what is a circular? Circular comes from the word circulate. Means to circulate. Circulate. So now your circulate means to circulate some information to specific persons or the addressees. So a circular could be a government, CBIC, the Central Board of Indirect Tax and Customs, issuing a circular for its own officers. A company issuing a circular for its own employees. A school issuing a circular to the parents. That's a circular. It is addressed to specific person. So therefore you will see a circular will mention who is the authority and to whom the addressee is there and what message it is there. Okay, so a circular could be that on Independence Day, all of y'all will have to come at morning 8 o'clock for the flag hoisting. It is to all the employees, a circular. A circular could be to my current employees that listen to my current employees, to my current customers that listen, I am issuing a new product, I am giving you details about it. Beautifully done. We'll just see the format how a circular is made. So circular, there is no legal definition. It's very general. Just write in your own words and close. As I told you, it circulates information. It circulates. You can write disseminates information. Okay. Now it could be electronic mode or through letters, emails, etc. Also can be done. Authority details, subject will be given. Now this will be in the form of a letter. Remember in drafting I taught you all that some of this will be in letter form, in letter format. So now as and when we do, I'll tell you that this is in letter format. So letter format, how it is there, always you will have a letterhead. You will have a letterhead, okay, letterhead of the sender. So organization name. So maybe if it is a company issuing a circular, address, okay. Now in circular you have to mention the circular number. Circular number, date will be given, very very important. It's a letter, na? Date, to, subject, sir, madam. This I want you to remember, letter format for anything. I'll just tell you letter format. It should click to you that this is what I have to write. Date, to whom you are giving it, subject, sir, madam. Then you write, this circular has been issued by this authority to inform you about whatever it is. Okay, depending on the facts of the case, you have to write the thing. Okay, you can tell that if there is an effective date, you will mention that from when this effect will be done, or when you have to implement the any date, specific date is there. Instructions could be given, etc. Okay, and for any queries, you can write this general basic line that for any queries, you can contact XYZ, this phone number and email IDs for yours faithfully. It's a format, right? So to and then yours faithfully, done. Circulars are done. Then we come to circular versus public notice. What is the difference between a circular and a public notice? Anyone knows? A circular is generally to specific persons, whereas a notice is to a broader audience, maybe to public at large, to everyone. Okay, so for example, if we are issuing a public notice, okay, with respect to a notice of meeting, that anyone who is there, the public notice is there that a meeting will be held. If you all are there, you all can come and attend. A public notice is generally given in newspapers, right? Notice could be that a tender could be a notice, right? Given to everyone, larger audience base. Circular is to more restrictive, definitive class. That's the only difference. Here also we are trying to disseminate information to people. Now public notices is there. We will see, suppose if there is a in so many times in company law only we see whether there is a, they will write you that a public notice needs to be given. So when you are shifting your registered office, they will tell you public notice needs to be given. Okay, or in name change, if you want to change your name, public notice is required, etc. Okay, so public notice is issued to convey to a larger audience. Okay, and generally in public interest. So for example, if whatever reason is, let's say I'm issuing a patent, so government tells you that you should issue a you need to issue a notice to get if anyone has an issue, that all will be done for getting IPR, etc. The procedure notices. So it is a legal announcement, okay, which is there. How to draft, we'll see the format. Again, it will have to be in letter format. It is in a letter format. So then to whom are we addressing? To the public at large. To the format is the same. Just remember, letter format means there will be a letterhead. Letterhead will be given. Organization date, name, address, contact number, email ID, and a public notice will be given that to the public at large, dated, subject, that for what are you doing, this notice is hereby issued by so and so to inform, okay, to inform the public about all of this change, and then you will give whatever changes is there. If there is any reference date, if there is any, because see, anytime notice is given, a date could be given. Example, a customs authority issuing a notice that an auction will be conducted on so and so date, so we'll mention that. Okay, and you can write that sometimes notices are given in requirement of a compliance of law. So, and pursuant to section number 12, the company is hereby required to issue a public notice for change in registered office. So we are issuing under this category. For any questions, clarification, additional information, please contact so and so person, email ID, then your sign. Done. That is it. Okay, so similar newspaper advertisement is also the same. Okay, again, public notice for issue of financial statement, it comes in the newspaper. So similar lines, public notice, same format. Just remember what I have told you. That's it. Bids and tenders. Okay, so what is a tender? A tender is an offer, or it is an invitation to offer. It is a invitation to offer. That formally we are inviting offers to complete a particular job or a task, or to supply goods. Now let's see the next. Very, very, very important part we are coming to is from this chapter theory point of view. What is a letter of credit? One, very, very important. And second, what do you mean by a bank guarantee? Letter of credit and bank guarantee mark important from exam point of view. Okay, very, very important. Let me explain. So, let me explain through the help of an example. Now pay attention to this. Your concept will be crystal clear after this. Your concept will be crystal clear after I explain you. But you need to be with me. Letter of credit is issued, and this line also you can write in the exam. Okay, so every word I say, you can obviously quote it in the exam. Okay, so letter of credits are issued in international trade, where there is a importer and exporter. Now I want to import the goods. I tell the exporter that please dispatch the goods to me. Now the exporter is saying that if I dispatch the goods, what if you don't pay me the money? I am scared. So I need some assurance that it will be there. So after making the contract with you, I don't dispatch the goods. I don't dispatch the goods directly. I say, listen, I need a bank from your end to take your guarantee. So the bank, so the importer's bank, you will go, will issue a LOC, a letter of credit. They issue a letter of credit. So the importer will apply for a letter of credit. So this is the first part. You enter into a contract. Then the exporter says, get a guarantor for me. So the importer will then go to his bank and get called as the issuing bank. Why it is called as issuing bank? Because they issue the LOC, they'll issue the guarantee. They tell the exporter, don't worry man, you send the goods, dispatch the goods. I am giving guarantee. So this gives the letter of credit. Now they will obviously give it to the exporter's bank. Okay, exporter's bank it will be given. Okay, advising bank who advises the exporter. Okay, they will give it to the advising bank. The advising bank will then verify the letter of credit and tell the exporter that yeah, we've got the letter of the guarantor, the guarantee, you dispatch the goods. So goods will be dispatched. The importer gets the goods. Now the exporter is saying, now what about my money? So then the moment the goods have received by the importer, now the exporter, now once he ships the goods, now see, now this is the exporter will now start. Exporter will start, okay? See this. Now he ships the goods, then he gives the documents to the bank, advising bank, that listen yaar, I have given the goods, go and get my money. So he forwards of the document that listen, I have dispatched the good, this is the lorry receipt, this is the bill of lading, that is I have dispatched the goods, that details have been given. This gives your, then the issuing bank will verify all this and inform him, and then the payment will be made. So sometimes issuing bank only makes the payment, or whatever, the payment will ultimately be made to the exporter on basis of the contract. Concept clear? So if I understand how does it work, first exporter and importer enter into a contract. Then the importer will go to his issuing bank and tell him that to issue a LOC, letter of credit. So then the exporter's bank called as advising bank will look at the LOC. Okay, LOC will be given here, and then he will say, okay, fine, dispatch the goods. So then this guy will dispatch the goods. Moment he dispatches the goods, he gives the proof to his bank, who will further speak to the issuing bank and get the payment. Concept clear? Very simple. Yes or no? Now let's see what all it is there. Okay. So we saw the parties. First is who applies for a letter of credit. Obviously the importer will apply. Okay, the opener of LIC, that will be mostly the buyer of goods. I will have to go and apply for issuing a letter of credit to my issuing bank. Okay, beneficiary is whom? The seller or the exporter, and advising bank is normally in the seller's location. So advising bank is in the seller's location, na? Your advising bank is in the seller's location. Now, a few more parties are involved. Just imagine that could be there in a more bigger transaction, etc. Now imagine here the issuing, we had seen this thing, right? Till here we had seen. Now advising bank. Now what happens is the advising bank okay, now pay attention. Till now I am dispatching the goods. Now just a few more mild parties. One party could be there, one other bank could be for the payment, one other bank could be for, now this is just showing of a more larger transaction, more wider parties they are involving. So till now the 4 important parties we are done. Now just a few more parties they'll add in between, we'll finish and close it. First we start with the one party to verify the documents, one party to make the transfer, etc. So the first one is confirming bank. The bank, in addition to issuing the LC, undertakes the responsibility of payment under LC. So first is in addition to the issuing bank. So the issuing bank is there. Okay, so the exporter is telling to this bank, okay, issuing bank, that you have to pay me, but I don't trust you, get one more guarantor. So the issuing bank will have to get one more bank who will confirm that if the issuing bank does not pay, I will pay. So they give a confirmation that in addition to the issuing bank, I also take the responsibility of payment for the importer. So it is a double assurance. Importer's bank is their issuing bank, but now I don't trust the issuing bank also. I say I want more protection. So then you get a confirming bank who confirms that if the issuing bank doesn't pay, I will pay. Clear? Simple. So this is how they build the number of parties. That's it. Simple. Next one comes negotiating bank. Now one bank will be inside to verify whether the compliances, documents, etc. is in done properly or not, and then they will ask for the payment. So here they will claim the payment, etc. Now what happens? Negotiating bank, they will nominated by the issuing bank to negotiate the documents submitted by the beneficiary. Okay, now if the beneficiary, just understand, this is negotiating bank will just verify document compliances, that were the goods dispatched, were the goods received. Once all of that document, one separate bank is there to verify the compliances. If that is done, then he will say okay fine, everything is fine, payment can be made. Now who will make the payment? They have another bank involved called as, so simple, it could have been 4 parties only, but they have just added more and more parties. One is paying bank. Paying bank is nominated bank to make the payment. Paying bank, also known as nominated bank, is the bank which will issue to make the payment. So we can appoint, maybe the exporter's bank is not paying, someone else is paying. Now sir, how that can be possible? Now pay attention. Now pay attention. Okay, imagine if this is the exporter and this is the importer, right? Importer has to pay. So what happens is importer's bank is there called as a issuing bank. Now for whatever reason they are saying issuing bank will not pay, we have appointed someone else. All this will be decided first only, which will be called as a paying bank. This bank will pay the exporter. Sir, why like that? Maybe this is in one country and this is closer to this country. I have multiple bank accounts, so that is there. So whichever bank is, what do we care? Whoever is making the payment, we need the money. That's it. Okay, so paying bank is nominated that they will make the payment. We have some funds out there. It is in euro, etc. They will only pay. Now one other last bank is called as reimbursing bank. Okay, it is nostro account. Pay attention to this also. Similar thing, it is again a third party bank which the issuing bank maintains a foreign currency account. It is authorized to issue and honor the reimbursement claim of the negotiating bank. Simple. Reimbursing bank. Now pay attention. Reimbursing bank. this is specific to one account called as nostro account. Nostro account. Concept clear? Till here. So now we're just seeing it's a very simple, it's a nostro account scenario. Now what it is, let's see. So first thing is now the paying bank, okay, the reimbursing bank, the company that has to make the payment, issuing bank. Now what happens, this is, let's say, in New Delhi. It is in New Delhi. We are in New Delhi. Okay. Now we have to make payment to a exporter in USA. In USA. Okay. Now what happens is, this bank might have a account with another bank which is in USA only. So issuing bank opens account in a foreign bank. Let's say it's some random US bank. It will open their account here and maintain some funds here only of this bank. So what happens, currency exchange etc. is not done so many times. It's easier, faster. So if they have their nostro account, they will directly pay from here. So nostro account means what? My account is kept there in another bank in your country. That will directly make the payment. Okay, this is with respect to, see, this is nostro account. Let me explain. Now this is the Indian bank. They open separate nostro accounts in other countries with other banks. Okay, so this is bank 1, this is bank 2. With this bank 2, I have maintained my nostro account. I deposit like Paytm money I put in, and from there, whenever payment needs to be made, it will be made. So is the issuing bank making the payment? Answer is issuing bank has to make the payment, but it pays through its nostro account. Simple example, I tell that, listen, I have a Paytm account and from the Paytm account I will pay. Okay, so nostro account is there. It is a third party bank, where the issuing bank maintains a account called as nostro account. So the issuing bank will have a account. It is authorized by the LC issuing, it is authorized by the issuing bank to honor the claim. So what is the job of this bank is to obviously make the ultimate payment in international pay, and this is made on behalf of the issuing bank. Okay, documents, very simple. What is there? Now we see the types of letter of credits. Types. One is documentary versus clean LC. What is the difference between? Now we are seeing different kinds of letter of credit. So letter of credit is like a guarantee taken in international trade by a bank that my importer will pay it, you give him the goods. Okay. Now read and tell me what is documentary and clean LC. Do you understand? Documentary and clean LC. Okay. Very simple. Okay. Now documentary is all with respect to title of goods. Okay. Let's see. Or let's say, okay, payment is made only when in documentary LC, when the exporter submits a bill of lading as a proof of shipment. So when physical goods has been sent and dispatched and it has been loaded, a bill of lading or bill of loading will be there. It ensures that the goods have been dispatched before payment. So it is a documentary LC. What is documentary LC? Documentary LC is the exporter will have to show that he has loaded the goods, physically loaded the goods. So a furniture exporter ships goods at to a UK importer. The LC states that it is a documentary LC, that only when you prove the bill of lading, when you have loaded the goods, given the documentary proof, then the payment will be, then only the importer will make the payment, because importer will say that what is the proof that you dispatch the goods? So bill of lading. Now understand this, in clean LC, bill of lading is not required without shipping or documents, title documents. This comes in service agreements. For example, if I am giving a software service, then loading will not come only na. Shipping, I am not loading any physical goods. So clean LC can come in service agreement. For example, I am giving a advisory service. So we get a guarantor from you that the payment will be made after I give you the service. But actual service is not loaded on anything, right? So your bill of lading is not there. It's simple. This is mostly for goods specific, and this is not goods. Goods are not involved. So therefore no loading, proof of document, etc. will be here. Now we see fixed and revolving. Now what is a fixed LC? A fixed LC is basically, I come to you, I say that please create a LC. You create it, that much amount will be fixed and that much amount will be guaranteed. That's it. It's a specific fixed amount. Okay. Once the amount is utilized, the LC will expire on it and cannot be used again. So for example, that amount is used up, then that's it. It's only for one time. So I could say it's a one-time LC. Once the amount is used, this is over. You cannot reuse that document. A car parts manufactured in Germany exports part worth 5 lakh euros. Since the LC has a fixed amount, once the limit is reached, it cannot be used for further transaction. The amount is fixed. Now, exact opposite is if I say that it is a 2 lakh revolving LC, means every time it will keep reopening. If I'm business partners and I tell my bank that he is my business partner, whenever he keeps giving this, you keep reissuing every time. So a revolving LC keeps going for business partners rather than every time going to the bank, every time getting. So in your company law, if you remember, there was a concept called as shelf prospectus. Once I file it, I can keep going again and again. So it gives you multiple withdrawals done without specifying the limit. Once the payment is made, the credit limit automatically gets reinstated. Allows continuous of transaction within the validity period. Revocable is cancelable. Okay. So for example, whatever the terms of LC, it can be cancelled, then it is revocable. So for example, terms and conditions which are there, I say any of the parties can cancel it anytime. Obviously, that's not without prior notice, so it's not going to be used that much. What is used nowadays is irrevocable letter of credit. LC cannot be cancelled or modified unless all the parties involved give their consent. So irrevocable means non-cancelable without the parties' consent. So it is a more better assurance. Clear? Now we come to confirmed versus unconfirmed letter of credit. Okay. So if I see confirmed means what? There is a confirming bank. There is a confirming bank in the exporter's country that guarantees the payment alongside the issuing bank. I told you, you get double assurance. Here you get double assurance. That who gives you first assurance? For the exporter, the first level assurance is by the issuing bank. Issuing bank is taking the guarantee that they will make the payment. I say get one more guy. I want one more person to confirm that issuing bank, if they default, they will pay. So a confirming bank will come in. Clear till here? Done. Unconfirmed means what? Unconfirmed LC means the exporter relies solely on the issuing bank and no additional bank is giving a guarantee. With recourse and non-recourse. With recourse means what? Bad debts. Bad debts. Okay. Let's see. Who will be borne by whom? If the importer fails to pay. Now imagine the bank has a right to recover it from the exporter, is called as with recourse. Okay. So with recourse means what? The issuing bank made the payment. Now the issuing bank will tell the importer, now you may make me the payment, I made payment on your behalf. So let's say, moment the exporter loaded the goods, I saw the bill of lading, issuing bank made the payment. Now I will recover it from the importer. If the importer did not pay, then can I go to the exporter? So normally with recourse is not given. Okay. It is always without recourse. You cannot demand the payment from the exporter even if the importer defaults. Normally is without recourse only. Transferable LC and back-to-back LC. Okay, now pay attention. Transferable LC and back-to-back LC. What is a transferable LC? That if there is a exporter of goods, okay, I am exporting the goods and this guy is the importer. Now let's read, okay? Or a transferable LC allows the exporter to transfer certain part to another. The exporter allows that if let's say the exporter is a manufacturer and this guy is ultimately taking the goods and then distributing it. Now what happens is the manufacturer said that I'll give you 1 lakh goods. He said no, I'm not sure whether I can I want 1 lakh goods. I say listen, whatever I'm giving you the credit option that you can take these many goods on credit. You want, you can tell, bring in someone else, importer 2 also. Okay, you take it and you divide the work. That 1 lakh goods you have ordered, 50,000 he can take, 50,000 you can take alongside, so you can transfer how much ever you want. So I am giving you credit of 1 lakh goods. If you don't want, get someone else. You take 30, he takes 70. That is also fine. So I give you that option that you find another good, nice person like you and transfer it. Okay. So transferable LC allows the exporter to transfer or allows the exporter to transfer all or any part of the credit to another supplier. A fashion brand in New York places an order with an intermediary in Hong Kong. Intermediary transfers a part of the LC to another person, so that is also fine. Okay, so vice versa can also be done, but main thing is the order quantity can be distributed. Now understand what is back-to-back LC. Now back-to-back is very simple. It's not a transferable LC. It is basically that I come to you, I say that give me the goods. Let's see, I'll make this thing that where they may request the bank to issue a new LC in favor of the supplier using the original LC. Exporter, okay. Now this guy is the importer and this is the exporter of goods. Now till here pay attention. Now the exporter has to export the goods to him, right? Now exporter is saying that listen, I would when an exporter receives an LC, okay, he received an LC and a confirmation from the importer's bank. Importer's bank gave a guarantee. So I will now dispatch the goods. This will they may request a bank to issue a new LC in favor of the supplier using the original LC as a security. Now the exporter will have to deliver the goods. Now he will have to go to his raw material supplier to get the goods so that he can export the goods here. Now when he goes to his raw material supplier, the raw material supplier will say what proof it is that the importer will pay the money. I will give you the raw materials, you will make it and you will sell. So this exporter will show this, give a proof that listen, the importer's bank has given me a guarantee. So when he gives it to his supplier, it is called as back-to-back LC. So in back-to-back LC, what happens? The exporter, okay, gets assurance from the importer first. This assurance he gives it to his raw material supplier that listen, this guy is going to pay. I have a bank in place. So now pay attention. See, a Dubai-based based trading company receives a LC from a UK retailer for electronic parts. Since the company sources the product from China, it issues a back-to-back to a Chinese supplier. Okay. So the Dubai-based trading company receives a LC, a guarantee from UK retailer. Now once we got the LC, we will show it to our supplier that listen, we have a guarantor, so you can give me the raw materials. That's it. Now red clause and green clause. Now pay attention to this. Red clause, you ask for an advance payment, okay, for raw materials. For example, I tell that listen, give me some money, okay. So the exporter will say that I have to export the goods to you. Now just by a guarantee, I don't have even 1 rupee, just by your bank giving me a guarantee, how will I make? So give me some advance payment. Like how in business also, when I have to give you goods, I take some advance payment, that is called as a red clause. this for the raw materials. Green clause is I'm taking more money, more advance. It is a bigger advance that I'm taking to cover not only the raw materials but also warehousing, insurance, transportation, etc. So obviously if I'm an exporter, I would prefer a red clause or a green clause. I'll prefer a green clause because I'm asking give me money for advance payment of raw materials plus shipping the goods plus storing the goods. Okay, that's called as a green clause. Installment credit, your goods are shipped in installments. So for example, we say that I want 12 lakh units per year. Okay, but I want it on monthly basis. So every month 1 lakh will be dispatched. Okay, so the full value we make a contract, but the exporter must ship specific installments as per the time frame. Now the last one is called as a standby letter of credit. A standby letter of credit nothing but a bank guarantee. Okay, it is a guarantee. So the importer's bank is taking a guarantee. In guarantee, what happens? First, debtor will pay. On default, our liability is second. So on default, bank will pay. So in standby letter of credit, the bank stands by and waits for the importer to make the payment. So is a bank guarantee where if the client fails, only if the importer fails to make the payment, okay, then the bank will have to pay. Clear? So standby is where the bank will stand in the side. They will see that goods have been received to the importer. Now the importer will make the payment. If the importer doesn't pay, then I will pay. That's called a standby letter of credit. Okay. Now they give you the format. Format is simple like an agreement only. Bank guarantee is simple. It will have three parties: creditor, debtor, and the guarantor. Now guarantee could be a financial guarantee that basically if he does not pay, if so much amount has not been paid, or if the builder has not paid you this much money, I will pay. Okay. Where we will meet a financial obligation. That if a financial obligation, so if the promoter did not bring in the money, then I will bring it, like underwriting. Whereas performance guarantee is saying that I guarantee his performance, that he will perform on time, he will the time will be followed, the quality will be followed, he will complete the project on task. So guarantee could be that he will pay or he will perform. For example, if you have taken a loan, you have taken a home loan, and I give a guarantee, it is a financial guarantee. I take a guarantee that if he doesn't repay the loan, then I will pay. That's a financial guarantee. If I tell the beneficiary that listen, if he does not complete the project on time, I will pay you so much. That is a performance guarantee. Clear? So that's what they have given. Formats is all bylaws again. Now when you see bylaw, the definition itself in the Constitution of India is said it is a part of law. So can I take bylaws casually or no? So let's see the definition. Okay, we'll go as per the Constitution of India, the definition of bylaw. So under section 13(3), article 13(3) of the Constitution, bylaw includes bylaw within the definition of law. So law includes ordinances, etc., bylaws. Even when you go to section 3, subsection 29 of General Clauses Act, it says the laws include bylaws. Okay. Now, whether the bylaws are compulsory or no will depend on the framing of the act. Sometimes bylaws are recommendatory, but mostly it is mandatory to be followed. Okay, that is it. Then comes show cause notice. What is a show cause notice? Authorities issue notices to persons to show cause, to ask reasons why action should not be taken against them. In the show cause notice, it will be written what offense you have done, in how much time you have to respond, how much penalty clause is there, and if you don't appear, a one-sided ex parte order will be given. So a show cause notice is a document issued to a party requiring them to respond to an alleged matter. Okay. So here the show cause notice will be in the form of a letter only. So I told you letter format is what? You will have a letterhead, then you will give a reference of the the letter number, date, to whom, subject and sir. So date, to, subject and then dear sir, and in the end you write yours truly. Okay, and in a show cause notice you'll write that during the inspection we have identified that you have violated this provisions. In connection of the above violations, you have constituted an offence and so penalty will be there. You are required to show cause why action should not be taken against you. That is it. And now we come to standing orders. Now pay attention to this last part. What is a standing orders? Multiple times this will come. Okay, we'll see. So standing orders is nothing but a law which applies in your labor laws, okay, labor matters. So let me explain. Okay, so what is a standing order? So pay attention to this. So once you understand the concept, you will be able to build by yourself. Okay, so we are seeing what is a standing order. Sir, what is a standing order? Pay attention. Normally with your employer and workman, so we are talking of employer and workman, so they never used to have any agreement. So a standing orders normally is a terms and conditions of the work, okay, and all the details of the working, etc. Normally, if a company does not have any written standing orders, if the company does not have any written agreement with the workmen, automatically the model standing orders will apply. So model standing orders like if you don't have your own articles, the company law table F will apply. Similarly, standing orders are those the terms and conditions which apply by default, called as model standing orders. If the employer is saying that he will give better work condition than given by law, what is default given in law, then you will have to certify it, which is called as certifying standing orders, which requires consent of the trade union as well, okay, and the certifying officer. So again, what does it talks about the terms, the work, the how you will enter, what will be the leaves related, what is the sick leaves, what will be your terms of conditions. So normally when nothing is written down, automatically model standing orders will apply. Now it was there only in employer and workman matters. Now obviously the industrial standing orders has been subsumed under the Industrial Relation Code. So as per the amendment, now we have the Industrial Relation Code 2020, which contains a standing order. So what is a standing order, sir? A standing order defines the conditions of working, recruitment, holidays, leaves, etc. Okay, it gives a clear employment terms. Normally Industrial Relation Code says that wherever there are 300 workmen, okay, this particular act will apply. Standing orders rules will apply whenever there are 300 or more workmen. Less than that, no standing orders will apply. This is as per the latest law, that is Industrial Relation Code, that whenever you have 300 or more workmen, the standing orders rules applies, where it says that if you don't have any written agreement, automatically model standing orders will apply. Only if you are giving better work condition, then you can certify it. Certifying. So when you see what all it contains, you will say, okay, it's pretty simple. With respect to the work, so what are the provided in the standing orders? How late coming, what will happen? Shift, what will come? If I say one day you're late, I'll cancel your full fees. So that's not allowed. How the termination will be done, how dismissal will be done. So all the terms and conditions in the offer letter, what would be there, that would be given. That's it. Okay. And then comes the bail application. Now bail is basically, what do you mean by the term bail or bond? So a bond is basically a bail bond, you must have heard. So there is a written document, okay, where the person says that he will fulfill certain obligation. Okay. that you will fulfill certain obligation. It serves a legal assurance that the party will bonds are for following purpose. So bond is an assurance that the party will perform his obligation. So you'll just write this line, that the bond is a formal document where the party will agree that he will complete his obligation. Maybe it could be a surety bond, that if I don't do, my surety will pay. My surety is a person. Or it could be a surety or security bond. If I don't pay, you can sell off my assets. A judicial bond is in case of bail bond. You apply, in the court is telling you to create a bond. Sometimes even in customs authorities, etc., they are telling that a bond is mandatory. That's a different bond. Judicial bond is in a courtroom. Bail bond is again, if you don't fail to appear, then we will seize your security or we'll seize your this. And guarantee bond is again, so anytime bond in simple line means that you are agreeing to fulfill certain obligations. It's a legal assurance given. Okay, that is it. We have completed the entire lesson 1, all important things including the past exam questions. The formats I have taught you in the beginning. With this, your lesson number 1, which is really big, is over. Thank you. Till here, have you all understood? Yes or no? In the chat box, understood? Yes or no? If you have not liked the video, please like the video. If you have not shared the video in your one of your study circle, please share the video as well. Okay, thank you so much for showing the heart. Waiting for you all. Okay, just be a little more responsive so we can go to the next chapter. Our next chapter is lesson number 2. Okay, thank you. So now we'll be starting and completing lesson number 2 as well. I need some energy from y'all in the chat box, sending such nice smileys. Okay, puts a smile on my face. Again, so lesson number 2 I will be starting and completing. Okay, quickly in the chat box, can we start? All celebration in the chat box, just write excited yes or no to start with the next chapter and complete it. Imagine if I am doing like this, 3 days you all sit with me, chapter portion can get over. Okay, quickly. Also remember, if you want details of these lectures, you will get in my dream batch also. You can enroll with us. Do inform your friends as well. Okay, now we will be starting with the next chapter. We will take a 10-minute break, 10 minutes, and then we'll complete with this chapter. Okay, that's it. Till then, you all can complete something else. Okay, that's it. Okay. Hi guys, am I audible and visible to all of you all? So we can quickly start and complete this chapter. Let me know in the chat box if I'm audible and visible, so we'll quickly start and complete. Okay, just waiting for your confirmation whether I'm audible and visible so I can quickly start and complete the chapter. GTG in the chat box, excited, quickly, half an hour and I will complete this entire chapter for you. Okay, great. Thank you. Let's begin. Great, Ashwarya, great. Thanks for responding. Chalo. Hi, so we begin with our lesson called as General Principles of Drafting. Now the very first thing is just we need to understand what is the meaning of the term drafting. So drafting is an art of preparing legal documents. So simple line is, what do you mean by drafting? Is an art of preparing legal documents. In legal documents, what do? We merge the facts as well as the law. So it synthesizes the law and the facts in a structured language form. So they make it a very good combination of they synthesize the law and facts in a structured legal form. Great. Okay. Now, what we have understood the term drafting. Now we'll understand the term conveyancing. Now, conveyancing is drafting of property, including movable and immovable property. So here the definition is given in your Stamp Act. In your Stamp Act, let's go to the section. So this is the definition that you need to know. That what do you mean by the term conveyancing? So conveyancing means where property is sold, whether it is movable or immovable. Okay. Now conveyance includes mortgage, everything here. So section 210 we'll remember and we'll write it down. Okay. Now let me tell you what is conveyancing. Conveyancing in simple language means conveyancing is when you draft or it is drafting of documents where property is transferred. Now when I say property, it includes whether it is movable property or immovable property, both. So here they go on to tell you that sometimes this is the only immovable property, but the answer is it is both. Okay. So conveyancing is an art of drafting of property where they've written immovable property. However, later they go on to say in section 2 subsection 10 whether it is movable or immovable, both. And conveyance always happens inter vivos, among living persons. Okay, where living persons are there. So where living person is not there, it is called as will. Okay, so will is not a conveyance. So conveyance, it has to be during living person where property is transferred, movable or immovable. Okay. Now, so they're giving you examples of conveyances where property is transferred. So I could say sale, lease, gift, exchange, will. Okay, is there. The inheritance is not included as a transfer under the strict sense. So what I told you, that inheritance that comes through will is not included in the definition of conveyance in the strict sense. So a deed of transfer is a conveyance which applies both to movable and immovable property. So thus conveyancing is an art of transferring property, whether movable or immovable property, mainly as we saw inter vivos, among living persons. Difference between drafting and conveyancing. Drafting could be of property related or non-property related also. Drafting is there, here conveyancing, stamp duty is applicable, registration act is applicable. Okay, and conveyancing again is where movable or immovable property is transferred. Okay, so all drafts or all drafting is a wider term. Okay. So again, very simple. That drafting refers to preparing legal documents. It could be related to property or not. For example, I enter into a service contract. It is not a or a partnership on contract. It's not a conveyance. Whereas in conveyancing, it is a specialized form of drafting where property is transferred, whether movable or immovable. Okay. Next, documentation. Now, when I say documentation, okay. Now, as we saw earlier, also document is under section 3, subsection 18. The definition of document. We saw other acts also define document, but they give an inclusive definition that it includes everything else. However, the main definition is given in General Clauses Act that any substance upon which any matter, okay, whether written, expressed, or described, used for recording the purpose, for recording purpose, is called as document. We've seen that in earlier chapters also. Conveyance, I told you, you have to remember section 2, subsection 10. Now we'll see what is contract. Now contract, I told you, section 2, subsection H. How is a contract and conveyance different? Very simple. First, I will write the act that contract comes under Indian Contract Act, whereas conveyance comes under transfer of property, and section 2, subsection 10 of Indian Stamp Act. Second, pay attention to this technical meaning to understand the conveyance. Now, in contract, now pay attention to what I'm saying, okay? Very important to understand the difference. So not this, I'll just explain nicely that a contract is a promise, right? It's an agreement. And what do you mean by the term agreement? It is a set of promises to be completed. It's a set of promises. Definition is given under section 2H of Indian Contract Act. Okay. Now understand the term conveyance. Conveyance basically is where property is transferred. So when I say property is transferred, means registration must be completed and stamp duty also must have been paid. Okay. So that means there are no future promises etc. involved. Everything is completed. So on the end of completion of your promise, I can say that it becomes a conveyance. So for example, if I make an agreement to sell, that I will sell it to you, it is a contract, or we enter into a contract, but contract is not a conveyance till all the essentials are there to make the transfer of title. In conveyance, there is a transfer of title only, ownership, because property is conveyed, is transferred. This is the main essence. Okay, now pay attention to this. That contract represents a promise, whereas conveyance shows as a completed act. All the promises are completed. Contract creates obligation, whereas there is no obligation. It is over now. Obligation. Actual transfer of ownership happens. Now a contract could be specifically enforced. So specific performance could be done of contract. That if he is backing out from the contract, etc. Conveyance you cannot do, because conveyance is where specific performance not needed only because performance is done. Okay, that is why, because everything is already completed, executed, registration, everything is completed. That's important. Okay. General principles of drafting is very basic. You have to remember Flower's principles. What do you need to remember? Flower's principle. Now this guy's name is Flower. What he had told, that there are some principles that use the familiar words rather than far-fetched words. Means whenever you're drafting, these are some general principles of drafting that you keep in mind, that use familiar words which everybody knows rather than extremely unknown words. Use concrete words rather than abstract, unknown, or very vague words. Use single words instead of phrases. Okay, so prefer single word. If one word is there, just do that rather than mentioning the full sentence. Use short words instead of long words. So they're trying to say keep it simple. And use sanction instead of Roman words. Okay, so we should use sanction instead of Roman. Sanctions origin words are more clearer, and that is why they are preferred over than Roman words, Latin words. Okay. Now Then we see the another important part of the chapter is deeds. Okay, what do you mean by the term deed? I told you deed. There is one guy. His name is Norton. His name is Norton. You have to write his entire definition. A deed is a writing on a paper, vellum, parchment, signed, sealed, delivered. That's it. You'll write the definition and then you go to the types of, and this case law also you want again. All instruments are deeds, but all deeds are not instruments. So only instruments, okay, which requires, so we can say that the broadest word is a document. Then I could say documents in which right, title, interest is transferred is an instrument, and those instruments which need to be signed, sealed, delivered are deeds. So deeds are the most compact thing here, and the widest is document. The document definition we had done section 3 subsection 18 multiple times. Okay, now when you come to the types of deeds, very important. A good deed is one which is conveys the title, ownership gets transferred, is a good deed. Okay, a good deed would ideally be marketable, sellable, and it transfers the ownership of land. So that's a good deed. Inclusive deed is where the boundaries of the lands are included. For example, in the deed, it is mentioned that you have the land from this to this. Clearly, it is given. A latent is basically where 20 years or more are passed and it is kept like that only. So a deed which is kept for 20 years or more in a man's strong box. In a man's strong box is like a cupboard. So I opened the door, I came to know a deed is there of past 20-30 years. That's a latent deed. Normally due to Limitation Act it might not be implemented. A lawful deed is which conveys a lawful title. A pretended deed which looks prima facie pretentious, it looks legal but it is not. A voluntary deed is where a without valuable consideration, like a gift. A warranty, where a warranty is there, a covenant of warranty. For example, if you go to buy an AC, okay, you get with warranty. Similarly, with respect to property, you might get a warranties. Multiple warranties can be given. For example, with respect to title, any ownership issues there, I will indemnify. Or I can also give that a house is under good maintenance. Multiple other warranties are there. So a warranty deed is a deed containing certain promises, covenant of warranty. A special warranty is where only doesn't warrant anything except title. So when I warrant only and only title, it's called a special warranty. But apart from title, if I give 100 other kinds of promises, then it's a normal warranty deed. A special warranty deed doesn't give warranty for anything except ownership rights, that I'm the owner and I'm transferring it to you. Okay, deed pool is where there are 2 or more parties, and how many ever parties are there, that many copies will be made. Deed poll is executed by a single party only, which is called as a power of attorney. Deed poll. Poll means one, pool means many, 2. Now remember I told you that whenever we write indenture, this indenture you can write this indenture. Indenture means what? A very simple word. It means 2 or more parties. So in any place where there are 2 or more parties, it is called as an indenture. Normally in olden times, they used to indent, okay, or create a parchment. They used to sever the thing so indent means to tear. So it was written in duplicate upon one of the part of the document and then they used to tear it. So they could do that. When they would join it, it would help you identify all the parts put it together. They could make, so we will come to know it's an original deed, and forgery is impossible. Forging. So they would tear the document. Okay. In olden times, it was a practice to make as many copies. The instrument were used. Parts used to be there. Like 2 parties are there. They'll tear it and give it in 2 pieces. Now, obviously, you think this must be valid. The process of actually indenting, actually tearing has ceased long ago. Now comes xyrographeme. Now xyrographeme is also a type of indenture where you tear but you write the word xyrographeme in between through juggled lines. So the xyrographeme is where 2 or more copies are made and parchment means the part is cut and you write the word xyrographeme in between. The idea is to make it difficult that another parchment wouldn't just fit exactly. It is a safeguard from fraudulent substitution. Deed escrow. Now this also I told you indenting of such kind of ceased long ago. Deed escrow. Deed escrow means what? It is escrow means it is still incomplete. It is also called as incomplete deed. See here they will give you somewhere that it is incomplete because signature of one party is left. A deed signed by one party and delivered to the other is in the escrow. It is not a perfect deed. It's an imperfect deed. Okay, so one party has signed, the other person's sign is still left to be made. The deed is operative obviously when the last party signs the document. Okay, then all this recitals etc. So all this I have explained in when we did the draft. Okay, so in the draft I told you what you need to remember is recitals. Recitals are the short story. Narrative recitals gives you a narration of the parties, what they do. Introductory recitals give you about the deed related details. So whichever I'm highlighting only that is important. Parcels you can remember. Parcels is basically legal incidences that they call it. Legal incidences thereof. Now pay attention. Parcels means what? So when you sell the house, you also sell the windows, the doors, the locks, the keys, etc. So parcel comes from section number 8 of Transfer of Property Act, that they say that whenever you sell, you sell the property along with the legal incidences. So these legal incidences are nothing but the parcels. What does it mean? That if I am selling my AC, obviously I am also selling the remote. So when you sell the machines, you also sell the movable parts with related to it. When you sell a house, lock, keys, doors are also given. When it is a debt has been given, so obviously it also interest that will occur in future will be included, not past. Money is there, so the interest income will also come of the future. So all these are parcels to it. So that goes along with the property. Redundum, I told you it is specifically to the lease related, whether lease deeds or what is the lease rent, all the lease related information is there. It's specifically for lease aspects. Testimonium, it starts is a closure of the agreement. It comes with the in witness whereof. We had seen when we had done the drafting, okay, in my formats when I had explained it to you. Supplemental deeds are basically additional legal agreement which you want to modify or clarify certain deeds. For example, if landlord and tenant enter into a lease agreement, so it's a lease agreement. Later they realize that they want to add a few more clauses, so they will make a supplementary deed, additional document, and supplement it and attach it. So here everything new need not be added, or the full agreement need not be made, only new facts will be added. That's it. Minor changes can be made through endorsement. We'll come to what is endorsement in the next one. Okay. Now important terms. So this is easy that we've done. All this not important from exam point of view. Obviously they are generic. Some English words etc. Not that. Not conceptual. Then aids to clarity. Now pay attention to this. We had done one topic in executive which was called as interpretation of statutes. What we had done? Interpretation of statutes, right? We had done interpretation of statutes. In that it helps. What does interpretation of statutes do? That whenever a law is ambiguous, is confusing, we will apply some rules to understand it. Similarly, whenever there is an interpretation of any deed required to be done, of a document need to be done, okay, deeds and documents. So that time you will see whether the document is either a formal document or it is a informal document. Okay, so you have to identify that if I want to interpret a document, I will look whether it is a formal document or informal. Now formal, there are formal rules. Informal is very simple. For example, when I'm making a will. Now when you're making a will, it is made a very informally. There are no very specific formats etc. But whereas I make a arbitration, your technology transfer agreement, your M&A agreements, obviously these are more formal in nature, require a certain formatting. Will, what happens is I call one of my child as Chintu. So I might not even use the name exactly, I might use the word Chintu. So informal agreements have one rule, that go into the shoes of the maker, see how he wanted everyone else to understand it. So in informal agreements, the interpretation should be done as per the maker of the document wanted the world to interpret it. So what I wanted everyone to understand, that I have to see, that what this guy really wanted to say, that will be seen in informal. Okay, let's see. So they word it a little confusingly, but you can write it. So whenever we have to understand certain words, etc., we apply the rules of interpretation. First one, informal agreements. In interpretation of informal agreements, the rule to be applied is that of rule of reasonable expectation, that what should we reasonably expect, that we have to look into the intention that is so whenever there is an intention is being ambiguous, we feel that there are two meanings, then we have to interpret in a way that the owner would want to express himself. So just write in own words and close it. Formal agreements, there are certain rules, like primary evidence is better than secondary evidence. Okay, just a few points you can take. In case of uncertainty, you can look at the recital. Clear and ambiguous words are there, then you don't need to go into the. So if this is your the first rule of interpretation that is there, that if everything is clear, that is called as a golden rule, or your one is rule of reasonable construction, the other one is your literal rule. Okay, literal rule. So you will go as per that. You look at the surrounding circumstances to identify the meaning. If there is an executory and executed, the executed one will prevail, means the one which has been completed, that will be seen. Okay, so just few points. Hardship to any party is not a matter to be seen. Okay, just few points you can remember and close. Okay, recitals normally are not looked for evidence. However, if the agreement is ambiguous, then we can refer the recitals also. Then comes endorsement. Now endorsement, if you remember, if it is a blank check, then or whether it is a transferable check, then in behind you endorse it. So that is always written at the back of the document. A bill of exchange can also be endorsed, right? So that is what they are talking about. That on the back of it, you write an endorsement to whom you want to further transfer it. The purpose is to create new facts, give some rights to a new party. And with this, we have completed the chapter. Stamping of documents is basically paying the stamp duty on it. Okay. Nowadays, you can also pay it through e-stamping. Okay, rather than physical stamping. That is it. We've completed the entire chapter number 2 as well. Thank you. Clear? So all the important parts I've covered. You don't have to worry all this. Some of the things are very easy also, which will come in the other chapter. So that I've moved faster. Okay, so whichever is important from exam point of view, I'm covering those. If I've skipped it, you know that it's not important. Now we go to the next chapter. Let me see and take up some good easy chapters. Okay, now this power of attorney act etc. is there. This one, but I think it's full theory. Hardly anything in it. Registration act etc. So many things are there. Registration, leave and license. What is difference between endorsement and supplement deed? Very, very simple. Supplement deed is a wider term. Okay, it could not necessarily be a endorsement, means you're trying to transfer a right to someone else. Okay, so when I endorse it, it is endorsement to someone. Okay, it also creates a new fact. Supplement deed is basically, where even you can create a supplement deed to endorse it to someone. So supplement deed and endorsement is written at the back of the document, endorsed to so and so. Supplement deed is basically when the landlord tenant is there, the landlord tenant is saying, listen, during rains you will also do the waterproofing, please, we'll enter into a separate document, a supplementary document where we'll write that everything is there, we are inserting clause number 11 more. So that's a supplementary deed. Clear? Now, this is, I don't know whether we should do this because it's all executive. This entire chapter is executive. It's a specific relief act, etc. Your Indian Contract Act, etc. So I think we can skip it rather than waste our time here. And plus, it's not even that important from exam point of view. Now we're looking at your agreements, okay? Okay. So we'll take a 5-minute break and then we'll come back and complete this chapter also. So all this now drafting part is all only theory we have to do. Drafting I've taught you, okay? So we'll start in 5 minutes. In 5 minutes we'll come and complete this chapter. Clear? I'm not covering the earlier one because Contract Act, Specific Relief Act, Stamp Duty is all executive. Registration of documents, all those things are only given. Okay, so executive stuff doesn't make sense. You can read it or write it in case it comes also. So we'll start in 5 minutes with this lesson. Okay. So we start with the next one. Okay. Okay. So we'll start and complete this lesson. Okay. Great. GTG in the chat box quickly, so I know I'm audible and visible. Okay, great. So now we start with the lesson drafting of agreements, deeds and documents. The drafting part I've already covered in the beginning, so drafting of all of this will be covered. Now we'll just be doing the theory part of it, okay, and something which comes in the exams. So all these drafting agreements, all we will be able to draft it simply by learning the templates. Now the first thing is understanding what is a power of attorney. Now understand, a power of attorney is a combination of, it's nothing but a laws of agency will apply. So there will be a donor of power, and the other one will be a donee of power. So anyone who has a right to do something, he has also has a right to give it to someone else to do it. For example, in case of company law, your proxy form is a kind of a power of attorney. Now, power of attorney comes under the Powers of Attorney Act 1882. Okay, and the laws of agency will apply because all the acts of the agent will be that is the donee will be treated as the acts of the donor. Now, power of attorney is divided in two categories. The first category is called as a general power of attorney, where you give your attorney, your agent, more than one power. So that is to do more than one act, maybe like a company giving its directors general powers to do multiple things, to its managers to do multiple things. So it is not restricted to one transaction. If it is restricted to one transaction, then it will be called as a specific power of attorney. So a special or a specific power of attorney where it is given to do one specific act only. Okay, a single act, a very specified definite act. For example, if we give a power to the company secretary to go ahead and incorporate a company, so that power is a specific power only with respect to incorporation. And normally, as we saw, always power of attorney starts by or know all men. By this power of attorney, I hereby give to my attorney the following powers. All his acts will be deemed to be my acts, and I hereby agree to ratify and approve them. So those lines you can write. Okay, I hereby undertake to ratify and all acts, deeds, and assurances done and executed lawfully under this power of attorney. Then comes lease. Okay, so lease is a transfer of a right to enjoy. So it is a transfer of a right to enjoy. Okay, comes under section 105 of the TOPA Act. So here imagine here special there is a transfer of interest. Remember here that in this lease there is a transfer of interest. Transfer of interest means an essential right will be given. So the lessee, the lessor is the one who is giving the power. To the lessee, he gives some significant powers where the lessee can do alterations, generally for longer tenure, etc. Okay, so the one who transfers the powers. So on my land, I say you can go and construct a factory. So I am the lessor, you are the lessee. We will give lease rent called as a premium. Okay, the price is called as a premium or the lease rent. Now remember, when there is no transfer of interest, that same thing will be called as a license. A license is a right to do something on an immovable property which would otherwise be unlawful. So there is no transfer of interest. In lease, there is a transfer of interest. Transfer of interest means an important right is being transferred. Okay. Leave and license, as I told you, a license is nothing. It's given under your section 52 of your Easementary Act. Easementary Act, which simply says that a right to do something upon an immovable property which would otherwise be unlawful. Okay. So this comes under section 52 of the Easementary Act. License, leave and license agreement. In leave and license agreement, the no essential right is given to the licensee. You can anytime want revoke it. okay, and cancel the license also. Then we had seen mortgage. Now mortgage is given under section 58 of the TOPA Act. Okay. Now in mortgage, what happens? You keep a immovable property as security to get a loan. So there is a transfer of interest in a immovable property for securing payment by way of a loan. Simple. Now there are types of mortgages, very simple. Types of mortgages will be, if it is a simple mortgage, there is a personal covenant to pay the money. For example, I simply say I will pay the money. That is a simple mortgage. You personally bind yourself to pay the money. So the mortgager mortgages his house and the mortgagee pays the money and he gets the security of that house. Okay. Conditional mortgage, it is a conditional sale. Okay, if by the due date you don't pay, the sale becomes absolute. Okay, it's a conditional sale. So in terms of sale, you will say whether the sale is absolute or the sale is void. Usufructory mortgage is, you can never sell this property. It is only kept as security, and the mortgagee only has a right to hold the property till all the lease rents are there. So here in the usufructory mortgage are those properties from which there is accretion from the land. There is accretion from the land, so these accretions will be set off against the principal and interest. Mortgage is where you personally bind yourself to. So there is a absolute transfer and a retransfer. So there will always be a absolute transfer and a retransfer. That means in English mortgage, you make the so the bank, you make them the owner, and you tell them when I repay the loan, you make me owner back again. So I transfer it absolutely to them, I make them the owner, and I tell them that when I repay the loan, you make me owner back again. Mortgage by title deeds or equitable mortgage is very simple. You keep the title papers with them. Very simple from the name itself. Anomalous mortgage could be a mixture of all of them or a completely different mortgage altogether. Okay, so all these mortgages types they have given, very simple. Now coming to gift deed. Gift deed is covered under section 122 of the TOPA Act. What does it say? That gift has to be accepted. Gift is without consideration. Okay, and gift could be done of movable or immovable property. It has to be voluntary, without consideration. The person who's giving is called as a donor, who's getting is a donee. Okay. Gift of immovable property has to be registered. So very simple, as per Registration Act, gift of immovable property is mandatory to make the gift complete. Gift of movable property can directly be given. Okay, immovable property needs to be registered. Movable property can directly be given. I can give my pen to you. I can give my watch to you. But sometimes if we are gifting a car, still you have to do the registration work because Motor Vehicles Act is mandatory. Okay. Now sale deed and agreement to sell. So agreement to sell is a future executory contract. Ownership is not yet transferred. Okay, it is not a contract. Okay, it is an agreement. Whereas a sale deed is all complete and everything is being transferred. Okay, so you cannot back out because it is completed. In agreement to sell, you can cancel it. Then you see ADR, very important, newly introduced your alternate dispute resolution. That nowadays parties have are looking towards settling disputes other than going to court. This is called as ADR. You have arbitration, conciliation, one of them. Okay, so the most common and recently arbitration we know. Okay, so you appoint a sole arbitrator, etc., who gives a decision, whose decision is, who gives an award which is binding. Okay, so here they have agreements where you are appointing an arbitrator, or both of them are appointing a third arbitrator is appointed, etc. Now they've also introduced something called as conciliation. Now arbitration could be in the form of a separate agreement or a clause. So I can have a simple clause. Nowadays companies enter into clause only in the main agreement. So if I'm having a technology transfer agreement, in that only I will have a arbitration clause, saying that if the parties cannot resolve the dispute themselves, they will settle it through arbitration. Or you can have a separate arbitration agreement altogether. Okay. Now mediation is also there. This is giving you examples of mediation clause and a separate mediation agreement. Okay. In mediation, what happens? You try to resolve the dispute with the intervention of third party, but the decision of the mediator is not final. Only the mediator shall try to use his good offices, his techniques to resolve the matter by interpreting the issues, etc. Okay. Settlement agreement is where the parties or maybe the employer-employee dispute has been settled. So it's the same format of a agreement only. Employment contract is like a service contract, same thing. So you will have offer letter will be given. So both the parties and the duration of the work, termination, salary amount, etc. will be given. The employment agreement. Okay, they also call it as service agreements. Settlement agreement is where you have settled a particular dispute. So this settlement agreement could be made after a mediation, efforts, etc. Or between employer-employee settlement must have come. Family arrangement is also where parties have decided to settle the dispute amicably or create a clarification. Bylaws of a society, so not very important, but normally a bylaws of society will cover about the name of the society, what will be the parking related issues, any disputes with any dispute with respect to all of this goes to register of societies. Now all of this I have covered. If the depth one you want, you can go to the dream batch and do. So general stuff is there. We just running through all of this. Drafting of standing orders. So standing orders, I told you, is the written rules and guidelines that are applicable containing the terms and conditions of employment. So you will see that if a workman is appointed and what all will be there. So general stuff will be there about their working, stopping, termination, exhibition. Now coming to a show cause notice and reply to a show cause notice. So we saw initially that an authority can give you a show cause notice requiring you to answer or reply to certain allegations. Now when you reply, you have to individually catch each allegation and reply to it. Normally they've given an example of a section 138 of Negotiable Instrument Act matter, like check bounce. So whenever there is a check bounce and you have to reply to it, that they give an example, a legal notice for check bounce, that a check was given to you and you did not pay. It's a letter form. Legal notices are also in letter form. And you will reply also that we received your notice on so and so date and we hereby state as under, in response to your legal notice, that these are false allegations, etc. and we deny the liability. Okay. That is it. We have completed the entire chapter. It's mostly about the drafting part. If you know it, all the internal theory becomes very simple. Okay. Now, we look at another chapter that we can take up and complete. I feel let's take up something, because drafting related everything will be covered now. So let's look at your art of opinion writing and complete it. Okay. You want, should I go in the order only? Let's see the fifth one. Commercial contracts. Okay. Chalo, we'll just complete it, run through everything and complete it. Okay. Now we'll start the other chapter also. Hi. So now we will start with a lesson called as drafting of commercial contracts. Drafting I have already covered. Now we'll see the theory part of it. Okay. when we do, and the important ones I will touch upon. See, LLP Act or limited liability partnerships are covered under the LLP Act 2008. Now, whenever an LLP Act is there, you will see that there is limited liability and there is a partnership. So the persons working inside are called as partners, and those who are responsible to report to government and do all the filing are called as designated partners. Okay, all the rules, regulations, etc. will be covered in your LLP agreement. Normally, what all will you cover in your LLP agreement? The business type, the name, the profit sharing ratio, place of business, the brand name, the duration. Okay, with respect to retirement, death of the partners, etc. So this is a specimen of a particular LLP agreement. Very simple. I don't expect it to come, but it's very simple. You can attempt it. Okay, what all they will be discussing. Now we'll see the theory parts of everything. Okay, drafting I've shown you, that all will be there. Joint venture is also very simple. Okay, so two companies are coming together, so they will write company A and company B agree to decide the following. Now, foreign collaboration agreement. This is also very simple. It is nothing but foreign collaboration. Means there is a foreign entity involved. So you have to remember RBI can be there. There can be foreign exchange involved, etc. Rest all is simple. So when a company, Indian company, let's say a manufacturing company wants to get certain foreign technology from a foreign company, they will enter into foreign collaboration agreement. Okay, so here you will have non-compete clause. Here you will have a clause of, I am saying addition, that foreign collaboration, right? So they will be subject to the RBI laws, etc., FEMA laws, will respect to the FDI norms, etc. So how the investments will come, royalty, because if you're giving technology, then you have to pay royalty, duration of the agreement, training, etc. Okay, disputes will be held with arbitration. Simple. Now this is also very simple. Joint development rights agreement. So basically what happens is, giving an example what scenario they're covering. That there is a landowner, I'm the landowner, I enter into an agreement with the builder that we both will develop a particular building on this thing and we will sell, and whatever gains we get, we'll share it among ourselves. It's an agreement. Format will remain exactly the same, not anything important from legal point of view. Let me see where the legal stuff is there. So service agreement is an employment agreement, so all this will be given about job. Now when you see a difference between dealership, distribution and franchise agreement, okay, now pay attention that a dealership agreement, now this is something a little bit technical, that a dealership agreement is an agreement between a manufacturer, okay, distributor and a dealer purchasing inventory upfront. A dealer does not buy in bulk but for resale to other businesses. So dealership is a dealer buying the property. First let's see, franchise is, there is a franchise owner, he owns the brand and he controls the franchisee and is working everything. Okay, dealer is, I am a dealer of goods, so I'll buy in bulk and I'll sell it. Mostly I sell directly to consumers, whereas in distributor I don't sell to consumer, I sell it to a particular other business. So first is manufacturer sells it, let's say, to a distributor, distributor sells it to a dealer. That is what it is there. Okay, distributor is generally a wholesaler. Okay, they deal in bulk. Okay, they generally sell it to retailers. Difference between distribution, so obviously distribution are wholesalers and dealers are directly the ultimate ones who give it to the customers. Okay, a franchise agreement is between a franchisor and franchisee, okay, to open the business under the name of the franchisor's brand name. Okay, so the place will be in the brand of the franchisor only. Now in distributor, see franchise agreement and distributor. See in franchise what happens, McDonald's is a franchise where you take of that only and the franchisors have high degree of control. Whereas distributor agreement is I am a distributor, I could be selling to multiple brands like Chroma. Okay, I might operate in my own brand. A distributor will operate in his own brand like Chroma, Vijay Sales, etc. and they can sell multiple things in bulk or directly. So in franchise, you can only deal with that product what the franchisor has told you. Distributor is you can have your own logo and then sell. So Kohinoor shop might sell LG AC and Samsung AC, etc. That's a distributor. So just all the agreements and all of this is same in witness whereof. Just you have to just think that what from a party's point of view and build your agreement. Now outsourcing agreement. Now outsourcing agreement means what? That I try to outsource. You could say another word for outsource could be contract out certain non-core activities. So what is my non-core activity? That only I will outsource. I will never outsource my core activity. If I am into my specialization is that I will keep that, but maybe marketing is not my specialization, that I will outsource. Okay, so I hire specialists to cover those things. Okay, so generic things like business process outsourcing, human resource, like a company could be of USA with the human resource or the hiring part or the customer handling part, that's called as one business unit or one business process outsourcing is where one business segment like a in department like HR department could be there, customer department could be there, that is outsource. In technology outsourcing, you contract out development of technology. So you could have Google set up here and then here the Indians are building the softwares for abroad. Knowledge process outsourcing is for specialized knowledge which have a knowledge skill advisory like legal services which come in KPOs. These are all different kinds of outsourcing. You outsource, you contract with someone to build your IT, to handle some of your business processes or to handle your knowledge legal aspects. This is covered. NDA, very important, is NDA is a non-disclosure agreement. So it binds the party not to disclose confidential information. Okay, so mostly in terms of whenever company is entering into certain kind of agreement, JV, etc., they can have a confidentiality clause, or separately they can have a confidentiality agreement stating that all the information is confidential and the information should not be divulged to third party except with the consent of the parties. Okay, with this we've just taken a overview. Then comes very important e-contracts, extremely important. So where offer and acceptance is given through electronic means is called as e-contract. Okay, now there are types of e-contract. While doing e-contract, you have to follow all the essentials of Indian Contract Act, IT Act, and your Evidence Act, which is your Bharatiya Saksham Adhiniyam now. Okay, just like you have in a contract what all essentials are there, in e-contract also same essentials will be there: offer, acceptance, intention, consideration, etc. Now there are types of e-contracts which is very important. First one, click wrap, shrink wrap, EDI. These three are the most important. Let's see. First one, proper past exam questions have also come. Click wrap or web wrap. Okay, it comes that is a digital contract where the user must agree to the terms before using the service. For example, if I'm buying an antivirus software, you have to buy the antivirus software, then I put the floppy or the detail, then it will say, do you agree to the terms? That will come. So you have to agree to the terms before using it. So when I also download a software, Adobe or any editor, they tell you agree with the terms and conditions, then only you're allowed. Facebook, etc. is a term. So in click wrap, you have to agree before usage. Okay, so you have to agree before using. Very simple. Okay, now in types of click wrap, it could be I accept. They might have, if you remember any of the softwares that you use online, I accept should be there or OK will be there. I can clicking, and it is non-negotiable. You cannot deny and still move forward. Now when we come to your shrink wrap, okay, now pay attention to this. What is shrink wrap? So shrink wrap comes as a part of a packaging. So maybe antivirus will come here. This is a more correct antivirus. Here it will be more for software download. Software downloads will come here. This is more correct. And in shrink wrap, you have to first purchase the particular CD, and then it will come. Okay, the hardware product, antivirus. So user can view the agreement after view only the agreement after opening the package. So this comes that when I go to buy something, I buy a package, I buy a software, okay, or I buy a particular product, then I have to do I agree kind of a thing. Okay, so when you buy a CD-ROM and then you install it, the gaming software, then it will come. Shrink wrap. So shrink wrap, just remember the word wrap. It's wrapped. It's a packaged product. Okay, and this click wrap could mostly be, it's not a package out of the counter that is there. I must have installed something that will come. It's a digital product which might be there already. Now when we come to EDI, okay, electronic data interchange. Here what happens? Computer to computer message will be given. So if I have, if automatically inventory goes down, a automatic message is given to the supplier. So here it's a computer to computer network. Okay, it's a computer to computer network. A standard message will be shot that our product has gone below the minimum order quantity, please sell it, and it is always made between business partners. So my computer will be fed that whenever the product goes down or the minimum stock order quantity is hit, automatically to this person this contract should be sent and the goods will be dispatched. So it is automated, basically computer to computer message. So the humans do the automation and then the cycle starts working automatically. Okay, with this we have completed the entire chapter. The drafting part is one and the theory part we have completed. Drafting part I have shown you in the start. You do that, that's more than enough. Clear till here, everyone? So whatever is important from exam point of view, that I'm telling you that this is important. This comes in your exam and I focus on those parts. Is this clear? Yes or no, everyone? Now we go to the 6th chapter. Let's see which it is. Okay, so the important stuff we completed. Now this is our compromise arrangement. Let's see how much it is there. Very simple. Amalgamation, mortgage, we had done it. Just seeing what all contents are there. So they have repeated mortgage. So I think we can go fast and complete this also. Debenture, trust deed. Let's see. Share purchase is important. Okay. Let's complete this lesson 6 also. Okay. Okay. Good to go, everyone in the chat box. Yes or no? Quickly. See, how can you expect the questions? I have given you all the scanners. The scanner contains full questions and answers. 40 marks will be drafting, which I have covered in the very beginning, and the balance part will be theory questions. The theory question which I'm telling you, I know which comes in the exam, so all of those I'm telling you, these are the ones that come. So with me, if you're doing the markings, you'll be sorted. Clear? Good to go? Let's begin. Okay. Hi. So now we begin with the documents under Companies Act 2013. So in Companies Act 2013, we talk a company can do a mortgage, create a charge. Company has arbitration agreements, or company might enter into M&A agreements. So we will see some of those Companies Act 2013 point of view. Now when we start, we look at sections 230 to 240, which talks about a company having a M&A, mergers, amalgamation, takeovers come here. Now here, if we see any deed of agreement, it is nothing but just imagine that one company is a buyer company, the other company is a seller company. You have to quote that pursuant to section 230 to 240, a particular takeover is happening. In that, I would be writing that if one company is buying another company, what is the consideration? How much money is coming? How much shares are coming? What is the date of transfer? What is the swap ratio? Who is the valuer appointed? Okay, all of those specific things we will mention. Rest everything is just like a purchase, that all the under, if we are purchasing, which brand name the company will operate, the details about the employment, whether they will be removed, not removed, etc. Okay, and it is pursuant to a scheme of NCLT. What will be the revised share capital, etc. Now when we see mortgages, we had seen in the earlier chapter. Mortgage is your section 58, talking about a transfer of interest in immovable property to secure a loan. Now mortgages types are there, and each type they have given you. So when I'm writing the mortgage type, I have to keep in mind that it's an agreement. So the consideration is for loan, some property is kept as security. Second, I will say that when the loan is repaid, then the property should be retransferred. I would write that if the money is not repaid, then they will have a right to sell it off. And then I will mention specific things to the mortgage. So if it is a simple mortgage, I will have to write that he is bound to pay it. So that's specific things you should know, that what is the essential of simple mortgage. So this I told you all in the earlier chapter only of all the mortgages. Very simple. Okay. Then we see debenture trust deed. Now debentures are nothing but it evidences debt. Debenture holders are those who have a certain proportion of debenture holding in the company, where they get interest, and on a certain day they get repaid. Now to protect the interest of debenture holders, they appoint a debenture trustee through a debenture trust deed. And in the Companies Act, we will see that debenture trust deed. Okay. And debenture trust deed will be in SH 12. So what is a debenture trust deed? Very, very simple, that the company appoints a debenture trustee to look after the interest of the debenture holders, and then whatever powers have been given to the debenture trustee, that will be mentioned. Okay, this is your SH 12 by which you are appointing, and under Companies Act section 71 talks about debentures. Okay, so provision with respect to DRR, a special emergency meeting he can call, that he will get the insurance done, he will keep the title papers with him, he can file to NCLT, if he's not doing his job well, he could be terminated or substituted also. And these are the drafting parts. You will just learn the basics and build your answers, more than enough. Okay. Now we come to a concept called as shareholders agreement. Very, very, very important. Now shareholders agreement, what does it mean? Okay, let's see which is the previous part. We not missed anything important. Share purchase agreement. Okay. Now let's understand what do you mean by the term share purchase agreement. Okay. Now very important. In the exam it can come. or I feel one of the most important things in the chapter. So share purchase agreement is nothing but a purchase agreement. So I agree to purchase some shares. You are ready to sell the shares. The description of the shares will be given and how much you're being transferring. And it's a sale agreement, just like a normal sales would be given. Seller and buyer agreement. That's it. I'm purchasing certain shares from you. So details of the shares, the price, etc. will be given. Stamp duty will be paid, etc. Normally, when we enter through buying through digital means, it is automated. But if we are buying through a private company, okay, then you might enter into a share purchase agreement. So here we'll be writing that I am the buyer and I am desirous of selling, and XYZ is the purchaser, he is desirous of buying on the terms and condition mentioned below. That the money has been paid, receipt has been attached here with all the rights, title, future dividend, all will be given. Okay, so the same thing is given. You don't need to write like this. The format that I've told you, you can build it in that. That is absolutely fine. Now, there is something called as a shareholders agreement. Okay, shareholders agreement. Now, what is a shareholders agreement? Now, imagine we have seen Shark Tanks. Okay, what happens in Shark Tanks that whenever there is an investor, let's say he's investing in the company. Now, the company promoters, when we see in Shark Tank, they pitch, and the investors tell that we want certain rights into the company. We are pumping in money, so we give us one directorship. Auditor will be appointed by us. We are minority shareholders, so we should not be, you cannot sell off your shares to third party there. You should first offer the shares to us. If we want to sell the share, so you will give them thresholds also that we are investing provided that the IRR, rate of return, should be minimum this much. If not, how are the exit rights that are there? Okay, so all those things will be given. So a shareholders agreement is an agreement between the shareholders of the company. So investors also investing and the existing shareholders. So the new shareholders and the existing shareholders will have some agreement. I'll give you an example. Where I'm pumping in money, I'll tell the company, listen, that now none of y'all can take a loan without my consent. If I'm pumping in money, if the company goes into winding up, first money should be given to me. Okay. Now the question has been raised many times that what is the validity of a shareholders agreement? Validity of shareholders agreement. Okay. What will be the new ratio after that all will be written. Exit rights will be given. Okay. Now we'll see the validity, whether they've given you the, okay, so they have not given you, but I'll tell you. If a shareholders agreement is made, it is mandatory to be incorporated in the AOA. AOA should be amended accordingly, should be amended. So whenever shareholders make an agreement, they have to pass a special resolution, amend the article that incorporate that amendment into the articles. Then it becomes valid. Underwriting agreement is there that if the in case of issue, if it is undersubscribed, the underwriters will buy. So company might enter into an agreement with the underwriter saying that we are bringing out with an issue. If the issue remains unsubscribed, then the underwriter shall be liable to purchase XYZ shares on the date of from the closure of the issue. Within 60 days, he has to purchase the shares. Okay, that all will be given. Then they will know how to write resolutions. So resolutions are very simple. How to draft a resolution. Okay, it starts with the word resolve. That very simple format will be there for all resolutions. Okay, so if I show you a format for resolutions also, format for resolutions. Okay, I think I've covered it later chapters, but I'll just tell you how a resolution format should look like. Yeah, see, you can take a screenshot of it. This is how it will look. Okay, so here you will write the title, what is the resolution about. Okay, that what is the resolution about the title. So maybe a resolution to issue bonus shares. So resolve that pursuant to section 63, read with all the specific rules of the Companies Act and such other approvals as may be required, the company be and hereby accords to copy the title, issue bonus shares, shift the this, make an investment, give a loan, copy the title. Resolved further, any director of the company is be and hereby authorized to sign or file the necessary returns or do such acts, deeds and things as may be necessary to give effect to the aforesaid resolution. So first, when you start, you write the title, what is the resolution about, then you write resolve that pursuant to section so and so, read with rule number so and so, the company be and hereby accords to copy the title, what they plan to do. Then write that we are appointing so and so person to do all such acts, things, do such acts, deeds and things as may be necessary to give effect to the aforesaid resolution. Finish. This is how your resolution format will be. Okay, with this we have completed our chapter as well. Okay, so format we have made simple. Now we just see lesson number 7. Okay, lesson number 7 is art of opinion writing. What is the art of opinion writing? I'll tell you what is important from the chapter. Okay, first let's see if I have my okay. So art of opinion writing, it's a 5-marker chapter. I'll tell you what is important from here. Okay, what is to be done and what is not to be done. Clear? Till here everything good? Yes or no? Till here I want GTG in the chat box. Everyone, GTG in the chat box. Or let me cover one important thing which is called as pleadings. I'll cover one heavyweight chapter. Let's see. I'll cover a heavyweight chapter now, which is called as pleading. So rest all is very simple. Don't want to go through that, okay? Suits for permanent injunction. Let's see. Plain structure. Written statement. Specially petition. Appeal format. I think this will be. So this is an important chapter now what we'll be doing. Okay. Very, very important chapter. You can say 10-15 marks can come from this chapter alone. Okay. Okay. So now we are starting with a important chapter. Okay, I'll tell you what all is important from exam point of view also. Till now, GTG in the chat box. Good to go. Can we start? Yes or no? Then start and complete this chapter. Yes or no? Can we start and complete? Yes or no? I want from you all a little bit of response. Okay, Prashant, great. What about others? I'm going to start and complete pleadings. Waiting for your responses. Okay, so let's start. Hi, so we'll be starting with the important 10 to 15 marker chapter called as pleadings. Now, I have covered this entire chapter. You can get it through the Dream Batch or through our courses. It's given in the link is in the description of the video. In this lecture, what I am taking, I will be focusing specifically from exam point of view, what is important that can be asked. So let's start first. What do you mean by the terms pleadings? So a pleadings means before the court whatever you plead is called as pleadings in general words. So whatever you are asking, stating, mentioning before the court is called as a pleading. Now pleading includes, it is a wide term, it includes a plaint and it includes a written statement. Written statement. Plaint is basically whatever in civil matters, the application that you filed before the court is called as a plaint, and when you file a plaint, the respondent will reply to it. The reply is called as a written statement. So both of them is a pleading, because one is pleading through a plaint, the other one is pleading through respondent is also pleading through a written statement. There are rules of pleadings which we will see now. The first rule is your CPC 1908. Okay, you need to know some of the rules, order and rule number, which I will teach you, that you need to know. Order 6 rule 1 of the CPC 1908 says pleadings, as I told you, means either a plaint or a written statement. I told you about it means a plaint or a written statement. Now what is the purpose of a pleading? The purpose of a pleading is basically everything will be writing. We come to know what is the matter in controversy. We know exactly, the court knows exactly what is to be decided and what each party is contesting. So pleading is basically a written down version of the plaint, and the respondent will give his written statement. So the judge will come to know exactly what is the issue. Normally you're not allowed to speak anything beyond what is given in the pleadings. Okay, so the statements and responses are known as pleadings. When each party responds, it is in his pleadings. Now, so a plaint generally is you're telling what wrong has happened, what is the cause of action, and in written statement you're giving all your defenses. The object of pleading is clear: to narrow down the controversy, to give the justice, and each party and opponent will know what is the other side claiming, and each one gets a fair chance to respond to it. Now we are going to see the fundamental rules of pleading. Very, very, very important. Okay, fundamental rules of pleading. This you should know, that pleadings, whichever both the parties, whoever is pleading, must mention only facts, not legal citation, legal sections. Why like that? Because facts are to be told. Law, the court is deemed to know the law. So in my pleadings, I will tell that I approached through the contract, I did this, he did this, etc. I don't have to give section numbers and quotations and citations. That is a later part of the stage. The pleading contains only the facts. Okay, it must contain all the material facts and not immaterial, unnecessary things should not be included. So that you know that is not going to be very, very vast and volume. Must state the facts relied upon and not the evidence to prove them. Evidence comes at a later stage. If at all the facts are questioned, then the evidence will be brought in. In your pleadings, no evidence is provided, and it must be clear, concise and precise. These are the 4 fundamental rules of pleadings. Okay. So this now we did order 6 rule 1 we did in the starter definition of pleadings. Now we are seeing in order 6 rule 2, which says that it must contain only facts, not the law. Okay, the court will apply the law. The court will know the law. Okay, now in this rule there are certain exceptions where you have to state the law. Exception to the general rule that you should give only facts not law, where you have to give the law when it is a foreign law involved, where there is a custom involved, where a question is mixed with facts and law. Okay, it's a maybe mixture of law, you are questioning the law only. Legal defenses are there, like a legal limitation period, and legal inferences supported by facts. So in all these cases you can use the law. So when you are using a foreign law, custom, it's mixed up, is legal defense or legal inference. Legal reference is only taken. Okay, supported by facts. Now comes rule 2. Only material facts will be given. Now what is rule 1 we did? Only facts, no law. Now material facts is to be given. Now what do you mean by material facts? So immaterial facts, unnecessary facts will not be given. Too many unnecessary facts will create a confusion and divert from the topics. Material facts are those facts which are required to prove your case or your defense. So whatever is those things which helps you prove or disprove is to be proved. Rest all should not be brought in. All material facts for claiming or defense must be stated. No unnecessary facts should be given. This is the simple little rule that whatever is necessary give, what is not necessary don't give. Let's give me examples what should be done. Then the third one, rule 3, is facts not evidence. The third fundamental rule is that pleadings must contain only facts not evidence. Evidence is also not to be given, it comes at a later stage. Okay, give the bare don't mix facts with evidence. Evidence comes at a later stage. Okay, when one of the parties challenging any fact, then we will say prove, each one will prove it. Okay, so lawyer must differentiate between material facts and facta probanda, means evidence. So a lawyer must be able to identify what is a fact and what is a evidence. For example, if I am saying that I have delivered the goods, the delivery note is a evidence and the fact is that I have delivered. Only when the question raised up that he is saying he is not delivered, then I will bring the evidence. So facts which help must be stated in the pleadings. Evidence means facts that prove the material fact should not be included in the pleadings. So a lawyer should know that these are material facts or evidence. Evidence should not be given, material facts should be given. Okay. Then we see facts to be stated concisely and precisely. So again, only concise, brief, to the point in a particular paragraph form should be given. Okay, without complicating the or creating ambiguity. Other basic rules that it must be signed. Okay, verification, that is affidavit, will be given inside in the pleadings, as we had seen when we did the format for plaint. They had striking out the pleadings, amend. So whatever is a pleading should be removing the unnecessary stuff. Amendment in pleading. So for example, after giving the pleadings, I want to make the change. It can only be done with the leave of court. Leave means permission of court, where the court will speak to the other side and give them an opportunity of being heard or objecting to amending the pleadings also. Now comes suit for temporary and permanent injunction. Very simple, that injunction. Okay, now we'll understand what is prohibitory injunction, what is mandatory injunction, what is temporary injunction, and what is perpetual injunction. Very important. Okay, now let's understand what is the meaning of the term injunction. Entirely I will tell you in depth. Okay, so injunction, if I ask you what is the meaning of the term injunction, so injunction is an order of court, requiring the party to do something or not to do something. Okay, so order of court telling the party to do something is a positive injunction, or I could say it is a mandatory injunction. It is a mandatory injunction. Okay, where I tell you don't do something, it is a prohibitory injunction. Like if I have to give you an example, if I'm telling that you will have to pay compensation, it is an injunction to do something. You reinstate, hire the employee back, that is a to do something. If I tell you don't create one more flow, it is a not to do something. Okay. Now if this injunction, both of them, okay, could either be temporary or it could be perpetual, permanent. So if it is given in the beginning of the case basis of prima facie evidence that I feel that you've done something wrong temporarily till the final judgment is given, it's temporary injunction. Permanent injunction is done at the end of the case, where after all the evidence has been heard, now company will say, okay fine, this is the final order that I'm giving. It's permanent, means now it's not going to be changed. Temporary can be changed, is given at the initial stages of the case. Okay, temporary injunctions are regulated by the order, you can in CPC 1908, and permanent so order 39, and this permanent injunction is given in Specific Relief Act, section number 38. Okay, so this you can quote. Plain structure. So if I've taught you how we appear, the before the court how you present it, that is a plain structure. So done. Okay, so same name of the court, describing the court, the format which I have shown you, that is what it is. Okay. Now what is a written statement? A written statement is actually a reply to the plaintiff's allegations. So when you reply, your thing will also be the same, the format of the court, but only difference is you are replying. So each point has to be individually taken up, that para number 1 allegation denied, para number 2 allegation denied. So each one you have to say whether you are admitting it, denying it, or contesting it. Okay. Now what all defenses can be taken is they are giving you the defenses that you can take for as a defendant. Some of the defenses they have given you: denial, traverse. I categorically deny, I have not done anything, is a traverse. So they are giving you defenses. Mark it as important, it will be repeated again later. So traverse is a kind of defense where the defendant says that he has not done anything, he denies all the allegation. The second one is you confess and avoid. So you confess certain things, yes, I had taken the loan, but it is barred by limitation. You avoid it by a special defense. You admit the allegation but give some additional fact to nullify its effect. Objection on point of law. For example, if I say that there is so these are the types of defenses. If I say that an arbitration agreement exists and that is why this cannot go on, or if I take an objection point of law, could be a wrong jurisdiction, the court doesn't have jurisdiction. So these are the defenses that we can take. Dilatory plea, okay, argues that the trial should be postponed due to misjoinder of parties or another case on the same subject matter, like stay of suit. So dilatory pleas is to delay the matter. Okay, so I say that the wrong party has been done, this party has not been involved. Okay, so anything to delay tactics is dilatory pleas. That's it. Later part again they will repeat. Okay, denials, traverse, as we saw. So very important. These are they are types of defenses. You've done dilatory plea, delaying the trial, saying that your court doesn't have court fees is not paid properly, or there is a misjoinder of party, wrong party has been joined. Okay, or some kind of petition or document has not been received. So point of law, as I told you, some you can take like limitation act, confession and avoidance. You can also say set off, where exact monetary amount is set off against some monetary amount. In counterclaim, it is a separate claim made altogether, where the plaintiff now will act like a defendant. Okay, so a cross suit, you can call a counter claim as a cross suit. Now I have paid, so instead of me claiming, I am now claiming more, and now you have to give me. Now you come on the back foot. So it's a separate claim by the defendant against the plaintiff. It's like a cross suit. Now this is again important, you have to read it. drafting a reply, ensure that every point, important consideration, everything is denied. Okay, disputed issues are highlighted, because if something is not specifically denied, it will be deemed to be admitted. Okay, then they've given you the formats of this written statement, etc. You can go through it. Notice. Now again, a notice, as I told you, notice format is like a letter writing only. Could be given for a show cause notice, personal notice appearance, government can give you a notice, etc. We had seen. So always it will be in letter format. To, date, subject, and then yours faithfully. Okay. Then execution petition. Now, if you win the case, you have the order copy, but to execute it, that is to implement, implement or enforce it, you will have to file another separate case called as execution decree. You have to get a execution court decree where you can take the help of the police or the court to execute your decree. For example, if I won the case, now I have to go to the court to tell that this guy has possession, you have to remove him and put me. So now please send, so I will file an execution decree. Another example is court say that I have won 2 crore rupees and that guy has to pay me 2 crores, but he's not paying. So now I go and file an execution petition and now please help me recover the money also. That's a separate execution petition. Okay, to help you get the proper delivered, help you sell the house, appoint a receiver, appoint a give support from the police, assistance from the magistrate or the police can be sought an execution decree. Now, when we come to a very, very, very important part, which is called as special leave petition. Now, if you're unhappy with the Supreme High Court, you will go appeal where? Supreme Court. But Supreme Court you cannot just land up. Under Article 134 and 136, you have to keep in mind that High Court to Supreme Court, you cannot always go. You need a special leave petition. You need a special leave. Either High Court will give you a certificate of fitness that the matter is fit. So there is a very serious public interest, legal question involved. They will make it a matter to be fit to go to Supreme Court, or you can file it to Supreme Court directly. If High Court is not giving you certificate of fitness, Supreme Court can directly call for it under their discretionary powers. So High Court to Supreme Court, I need a SLP to go, a permission of the High Court to go. Now see, under Article 130, Supreme Court has the power to entertain even if the appeal is not hereby provided for. So even if nobody is giving you any permission to appeal, still Supreme Court can order under Article 136. It's a very rare power that they will use it. Okay, that Supreme Court will interfere with the findings of the High Court. So Supreme Court doesn't just pick up matters. Okay, here when we write, you have to write the section number. It is under Article 136, special leave petition. Rest all is the same. Now revision application. Now remember section 115 of the CPC 1908. Revision application is the higher court telling the lower court to bring the records to see the legality of its process. If they find that the jurisdiction has been exceeded, they will squash and replace it. They will revise it or replace the order. So how High Court is supervising the lower courts, that whenever the lower court has exceeded, not applied its jurisdiction, so jurisdiction errors is there, then the higher court will revise the judgment, squash it aside and pass their own judgment. This is like a writ of certiorari. See, the High Court may call for the records for any court subordinate to it if the subordinate court has done jurisdictional errors, did not have jurisdiction, failed to exercise jurisdiction, acted illegally or with material irregularity, then they will come in. Okay, revision powers. So remember the section number, section 115. Okay, then a format for appeal. So we have already done. Just like our petition is there, one additional thing will come that is called as grounds of appeal, which I have covered in the start of the video. Okay, grounds of appeal. So the grounds of appeal, I've given you the format also. of grounds of appeal, rest everything will remain the same. Then we come to writ petition. So writ petition is whenever your fundamental rights under part 3 are violated, you can file under 32 or 226 to the High Court or the Supreme Court. Now, under 32 is a type of right, it is a fundamental right, and this it is a constitutional right. Whenever all this is violated. Now, different kinds of writs have been given, okay, that you can just read up. We've done habeas corpus, certiorari, mandamus, prohibition, quo warranto. This is we've done in long time back also. In writ petition, just remember one important line, that you have to write that you're a citizen of India. Because normally some of the rights are given only to citizen of India. Okay. So just mention that if they have not given. Okay. Now, arguments on preliminary submissions, and which is the other one? Arguments on merit. Mark it as super important. Okay. So mark this as important and important. So what happens is, understand that my first line of defense, my preliminary submission in my defenses will be something which the matter only doesn't start. I don't go into the merits of the case. I have to highlight limitation period, barred by limitation. So the court will not go into the merit only. If I say that the court doesn't have jurisdiction, it is a preliminary submission, preliminary defense that I have to take. In the very beginning, this defense has to be taken. If I have to say that an arbitration agreement exists, so then I'll say in the very beginning only. So these are all my initial arguments that I will do, so that I don't have to get into the merits only. Okay. So any kind of procedural defects, etc. will be pointed out. But if the court really picks up the matter and now I don't have an option, then I have to go into the merits, prove why am I right, etc. on basis of the actual facts of the case, on basis of evidences, etc. will be seen. And legal notice is nothing but a notice, as I told you. It is in the format of a notice only, and reply also. For each one you have to individually reply. Okay, each matter, if specific thing has not been taken, it will be deemed to be accepted. So with this we have completed the entire chapter. Thank you. Clear till here? Have you all understood? Yes or no? Everyone in the chat box. Yes or no? You all are enjoying, just write enjoying in the chat box. Enjoying in the chat box quickly. Yes or no? All the important stuff from exam point of view I'm covering. You do my drafts and this video itself, you will easily clear. Everything will come from what I've taught you. Okay? In the chat box. Enjoying. Can we move forward? This is the last chapter that we'll be covering. I'll be telling this chapter. Okay? It's a very simple chapter. We'll be completing it. Okay. Great. Let's begin. Let's see what all is there. Okay. Hi. So we'll be starting with a chapter called as Art of Advocacy and Appearance. This chapter is very simple and very predictable what question will come up. First, they go on to tell you what is etiquettes. So etiquettes is your art of appearing before others, or art of behavior before others. Okay. Now, professional etiquettes is etiquettes or manners or principles to be applied in your professional life. Now here they go on to give you the basic etiquettes type. Now this you have to read through. Dressing etiquettes, how do you have to dress up according to the occasion, should not be very heavy colors. Okay, greeting etiquettes, conversational etiquettes, communication, this is important. Okay, they may ask in the exam. It's very simple, but it's a bonus marks. Okay, like tie your shoes, polish your shoes, keep your nails clean, etc. Then comes what is court graft. Okay, now what do you mean by the court graft? So court graft it is a 5-mark answer which can be asked. What do you mean by court craft? So court craft is basically how to appear before the court and how to argue before the court in a way that you can prove that your stance, your client is correct and your version of the truth is correct. So it comes as an art of advocacy. It is an art of advocacy. Okay. Now, role of company secretary. Company secretaries also appear before quasi-judicial body. That is why it is important for us to know. This code graft is about how do you win cases. The art of advocacy, convincing the judge that your interpretation of law is correct. Then the next important thing is advocacy tips. So this is again that has come. So some of the advocacy tips, as to be a good advocate, you should have a clarity of mind. You should be credible. You should not lie. Demeanor, your entire body language will speak volumes more than hearing you. So when your body language of your client, it seems the judge will look at your body language of your client, whether he's saying true or no. Have eye contact, voice modulation should be there. Okay, have a confident temperament and have a positive psychology and understand the judge's psychology also. Someone does a background check on the judges to see that which all his matters, what all his preferences, and try to tone your argument in that style. Okay, so that the judge follows you see what he likes, he doesn't like, and then try to frame your arguments. Be likable, learn to listen. Okay, knowledge and preparation. You have to prepare nicely, and order sheet. Order sheets are maintained in every proceedings by the court master and shall contain all the orders passed by the appellate tribunal. So you have to keep yourself updated with the order sheet also. Keep track of all the order sheets. Then one very important thing is called as rule of adverse inference. See, adverse means negative and inference means action. So here they say that anyone who has the best evidence should produce that before the court, even if it is unfavorable. If you don't produce that evidence, then court can draw adverse inference on you. Adverse inference can also be there on a person who is not the party. For example, a doctor who has a medical record, the court can order him to come and give because that will solve the matter. So rule of adverse inference means that the party who fails to produce the best evidence, the court will presume that is unfavorable and will take action against him. Okay, it is incumbent, it is mandatory upon the party who has the possession of the best evidence to produce such evidence before the court. And if you don't produce it, the court will be justified in taking action against you. Simple. Okay, dress code has been given, what you should wear and what you shouldn't wear. So here you can take this part, you can read that company secretary dress code. So navy blue, buttoned up coat, safari suit, professional dress for female members, sober colors. All this you can mark as important for company secretary. What is the dress code? So guidelines, attire, conduct for company secretary. Same thing they will repeat it. Okay. So you need to you can wear if you're navy blue dress code, necktie. If your employee has given you a special dress code, you have to wear. If the court has a special dress code that you have to wear, is what is being given. Okay. Restricted items. So what all is strictly prohibited? Unpolished shoes, shorts, scarves, hand gloves, face mask unnecessarily, clothes that are too revealing. Okay, all this is not allowed. Exceptions to the guidelines: turbans can be worn, headgear can be worn. Okay, if it meets the community norms. Hearing aids can be there for people with hearing impairments, and facial hair should be clean shaven unless it is for religious purposes. With this, we have completed the entire chapter along with the markings through the important things from exam point of view. With this, we conclude our entire marathon. The first part is where I've covered the 35 to 40 marks, and then I've taken you through all the chapters. The detailed details, if you want more chapters, if you want, you can go and enroll. The links are in the description of the video. With this, I conclude my marathon. Thank you so much, guys. I will now see you all in the next marathon. Wish you all the very best for your examination. Take care. Bye.